Bask in the outside and the inside in perfect harmony by choosing between 6 styles of apartment options and views that encapsulate your endless getaway. Envision waking up to the sound of breaking waves, a tranquil haven of indulgence. That's what the villas at Oceana offers you. Creating your perfect holiday home by the beach, complete with outdoor and indoor splendor, with interiors reminiscent of opulent Balinese villas. Our beach mansion villas are situated right at the foot of the shore, crafted to world-class luxury. With living and dining, 3 bedrooms, 3 washrooms, pantry and kitchen, family and TV lounge, beachfront relaxing deck and staff quarters. These beach mansion villas are meticulously designed exclusively for an uninterrupted holiday experience that epitomizes pure luxury. Our beach villas offer you an ideal experience. Choose your luxurious villa from 3 designs, accommodating 1, 2 or 3 bedrooms and a living room, dining room, pantry and kitchen, bathroom, relaxing deck and bar space for your perfect holiday haven. Once an endless holiday without endless amenities, Oceana offers access to 50+ world-class features you would imagine on a luxurious holiday. Our pool bar and lounge areas help you to unwind and enjoy the beauty of the ocean. Walk through the perfect indoor and outdoor social areas meant for relaxation so you can unwind in endless luxury. You can also keep active by taking a run at the beach and heading over to the gym packed with world-class equipment and professional trainers. Keep your youngsters entertained at our kids' play zone or even at our game rooms and activity zones. At Oceana, our mission is to create luxury near the ocean and give you endless experiences of an oceanfront resort lifestyle of living. And when we say endless, we mean it. Have a taste of an endless experience with Oceana Beach Resort Apartments and Villas, Vadua, a project by Homelands.
I can still remember when Tati made the house bigger for us.
I too played my role in the growth of our town.
I never thought my first job would take me so far.
It's amazing how our bridge just transformed this area.
Our little school got world-class cricket equipment and training.
We are rehabilitating this reef to protect Sri Lanka's heritage and the world's ecosystem.
Tati, I'm calling you from the 40th floor. And we're going higher, much, much higher.
Binding our stories together, past, present and future. The Tokyo Cement Group.
The reason why LOLC embarked into a multi-geographical strategy was mainly due to risk diversification and to broad base our customer base. In these countries, we find the SME market is huge, especially countries where we have a large population, where the SME sector has not been serviced. If you take the African continent, they have the highest growth rate in the world and the highest requirement, the highest need for microfinance. So that's where we are. Our key strength is our adaptability. We have proven it over and over again to various cultures, to various countries. And when we move in, we make sure that we absorb these countries into our system, into our framework, with the full cooperation of the team members in those countries and our customers. Technology has always been at the forefront of LOLC. Across these countries, we have moved our technology. We have iPay, we have introduced iPay into Cambodia, we have OES platforms, and all the latest digital developments in financial institutions are now being shared and serviced in these countries. We are a multinational, multicultural organization offering global best practices across the organization. Our ambition is to be a global player. Growth has always been by design, not by accident.
සමහර සම්බන්ධතා තියෙනවා හැමදාම අපි ළඟින්ම ඉන්න.
අපේ ජීවිතයම දුවන්නේ ඒ සම්බන්ධතාවයන් මත.
මම එක් පුද්ගලයෙක් හැටියට අපි එක රටක් හැටියට මේ සම්බන්ධතාවයේ වැදගත්කම අත්විඳලා තියෙනවා. ජීවිතයේ වැදගත්ම මොහොතවල් වලදී
රටකට වැදගත්ම අවස්ථාවන් වලදී
අපිත්
රටත්
ලෝකයක් යා කරන පුරුල්තම සහ වේගවත්ම
අප වෙනුවෙන් කැපවූ
ලංකාවේ අපේ අංක එකේ ජාලය ඩයලොග්.
හයි ඩයලොග්ගේ අයි මේ නෝට්ස් වලින් හෙට ක්විස් එකට ප්‍රැක්ටිස් කරන්න ඕනේ.
ආලෝක දර්පණයකින් ආපසු හැරෙන ක්‍රියාව නම්
ප්‍රතිබිම්බනය? yes.
කාචයකින් ආලෝකයේ විචේදනය වන න්‍යාය නම්
මැක්ස්වෙල් තියරිය? ස්නෙල් තියරිය?
ඩයලොග් AI නොඩම දෙයක් සිංහලෙන් නොමිලේ කරගන්න.
For over 86 years, Unilever has reached every corner of Sri Lanka, from bustling cities to quiet villages, uplifting millions of lives. With over 98% of our products made locally and one of the largest ecosystem of partners in the country, we remain committed to improving livelihoods and strengthening communities through our operations and purpose-driven brands. Our sustainability efforts focus on climate, nature, plastics, and livelihoods. At Unilever Sri Lanka, our purpose is to brighten everyday life for all.
Every Mercedes-Benz has a story, but only one begins where it should. Factory built in Mercedes-Benz AG. Zero mileage. Engineered to perfection. Tailored for Sri Lanka's tropical climate and roads. Professionally handled by Demo, Sri Lanka's only authorized agent, with all duties paid and no legal risk. Backed by the Mercedes-Benz AG Global Manufacturer Warranty and preserved by Demo's technical experts who know your star the best. This isn't just another car purchase. It's a transformational journey with Demo throughout your ownership experience. Demo, the home for Mercedes-Benz.
Discover the world's top 100 ranked university pathway programs now in Sri Lanka. Enroll with SLIT Global Pathways in the fields of computing, business and engineering. Secure scholarship opportunities with guaranteed transfer options to prestigious universities in UK and Australia, University of Queensland, University of Western Australia and the University of Edinburgh, UK. Grab your opportunity. Apply now at 077 622 8989. SLIT, the future awaits you.
A very good morning, ladies and gentlemen, and a very warm welcome to the 8th session of the National Law Conference here in Kandy. Ladies and gentlemen, the 8th session is on artificial intelligence, data protection, cybersecurity, and the digital roadmap for Sri Lanka. And we hope that everybody is rejuvenated and refreshed after an amazing gala night yesterday. And we're all ready for the 8th session. So without further ado, let me introduce the panelist for this session. Ladies and gentlemen, our first panelist, none other than the Honorable Chief Justice, His Lordship P. Padman Surasena. Sir, if you could make your way onto the stage and take your seat. Thank you very much, sir. Also, ladies and gentlemen, joining us on this panel for the 8th session is Dr. Hans Vijay Surya. Dr. Thusita Abesekara. Mr. Asela Vaidyalankara. And ladies and gentlemen, all the way from India, Senior Advocate Aruneshwar Gupta. And our panelists will be in the able hands of our moderator for the 8th session, Mr. Seshan Souza. Shehan Souza. Ladies and gentlemen, of course, there is one request from the organizers that no photographs be taken of this session only. So once again, a kind request, no photographs to be taken of this session only. Thank you very much, and it's to the hands of the moderator, Shehan.
Morning, everyone. So, we have to be thankful to the organizer, especially Mr. Priyantha Alagiyawanna, for establishing such an awesome panelists from India, our own Chief Justice, the National Consultant for Digital Economy, as well as Dr. Tusita, and I wonder why Mr. Asila Vaidaranka is outstanding at the moment, however he's sitting. Okay, so we will not be introducing all the panelists. They are well known to us, and we will commence straight away with our speeches. So, first and foremost, the Honorable Chief Justice, I want to mention something before His Lordship commences his speech. When me and Charna went to meet His Lordship, we were given an appointment at 6 p.m. We were lucky because His Lordship and the rest of the judges of the Supreme Court are working every day, I heard, from morning until 10 p.m. Now, I don't want to be a judge anymore, okay? So you can understand the amount of work they are doing. They have taken on, or they are shouldering the responsibility of clearing all the case backlog. Justice Samyavardhan mentioned on the previous day as well. So with that, we would like to know from His Lordship, the Chief Justice, what is the process of digitization with regard to courts? May I ask His Lordship to explain that?
Good morning, ladies and gentlemen. Thank you, Shehan, for the introduction. It is true that Justice Samyavardhan and I wait till about 10, 13, 11 in the Supreme Court. But yesterday we realized lawyers work more than that. And it was past 1 o'clock when we left. And also my friend who compared also said that we are rejuvenated and have come in the morning. In my case, I have lost the vigor I had yesterday also. In any case, it doesn't. Digital transformation of courts is just like what you see here. Can I get the laser pointer? In short, this picture says what I want to tell. Shehan, you will indicate the time when I get that. Now this is where we are, and this is where we are going to be. I am sure Dr. Hans Vijay Surya will touch on digital economy, but for my purpose, I will only say this: economic development of a country would depend on many things. Now, before I talk about digital economy, the normal economy, what we had earlier, road infrastructure, buildings, hospitals, police stations, schools, and so on and so forth. So that is the infrastructure on which any country would develop. Now we are talking about digital era. And it is for that purpose that the digital infrastructure must be in place, which I am not going to speak because it is a subject which Dr. Hans Vijay Surya will speak to you about. Now, on whatever the platform, either digital or non-digital, you have to increase the productivity, whatever the way. That is simple. And of course, minimize the wastage of resources. And whatever the method you do must be sustainable, international, and in accordance with international developments. And from 2, I will jump into 3. Now, international practices and international developments, and when we want to get connected to international platforms, you can't do it on the normal platform which we have been having. You have to transit from digital economy. So digital platform in non-digital era, all are paper-based and everything happens manually, and you have to physically go. You have to physically take the bulk of the brief that you have to file and go to the registry and hand it over and sign and all that. So that is what we have now. Now in digital era, no physical presence is necessary, no papers are required, no manual handling. That being said, in Sri Lanka, we have at least these items, these institutions, which you can see on the board, Registrar General's Office, Immigration and Immigration, that is passport, and telecommunication providers, water board billing, electricity providers, and all that. We get electricity bills, water bills, telephone bills online. Courts, not yet. Now, as I said before, it is manual paper-based courts and registry from digital system. Now, let me take a criminal case, for example, to show you what we have been doing. Now, I just spoke to, in the morning, to Mr. Jalia Senaratna and Mr. Nilupul Somasinghe, the police legal division, talked about B report. When a person is killed, I'm talking about a murder case, there is no case in the magistrate's court. I took that case because there are 2 courts involved, unlike in the district court and civil and district court and any other court and any other case. Non-summary is involved in magistrate's court and then trial is in the high court. That's why I took this example. Now, when a person is killed, there is no case in court that we know. That's normal. Then you file, the police will investigate and somebody will complain and file a B report in the magistrate's court. Then later on they will file information book extracts, post-mortem report, medical legal report, examiner of question document, government calendars, fingerprint reports, etc., etc. Then they will conduct non-summary inquiry. That is not a trial. And then the B report is just 1 or 2 papers, and then you see the case record has built up, and it's bulky by that. Then it is transferred to the High Court for trial in the High Court, which will also involve in evidence taken and cross-examination and for days and days, and then the record will burst into volumes. Then if there are 5 accused in the case, there will be, then let's assume the High Court convicts all 5 accused. And all 5 accused will separately appeal to the Court of Appeal, which means there will be 5 appeals. In the Court of Appeal, you know, the case has to be heard by at least 2 judges. And those 5, so the 3 briefs have to be prepared and given. And if the Court of Appeal also affirms, then you go to the Supreme Court. In the Supreme Court, 3 judges will have to hear that case, and then more briefs. You just discard that and prepare more briefs. Now I'm talking about 5 appeals. Whatever the amount of briefs must be multiplied by 5. So that is the amount of paper. Paper we are not producing. We are bringing it from outside. Toners, photocopy, the printers, scanners, the file covers, the space for storing, all that is resources. after the case, what happens to all those resources? Resources are waste. Because we send all files to some Valachene paper mill for them to convert it to pulp and again, again manufacture papers. So that is the wastage of report, wastage of the resources. So I will shortly show you some more things. Now this is Supreme Court record room. And now you see how much of this is one case. Just one case. One, two, three, four, five volumes. Others are also recorded. Now I told you about evidence being taken in the High Court. In the Appeal Court and Supreme Court, there is no evidence taken, you know that. Now, evidence taken down by the stenographer and typed on the computer. Then what do? They don't store that, they take a printout and file it in the record. So that is how these records become bulky. When you can very well store that in the computer and build, and their own continue to build the soft copy. You don't do that. I don't know why. And if you do that, now this record, the record room is not necessary. So moving ahead, now this is just one case. Imagine, this is just one case. This is, I think, a golden key case in, I believe, 1991. The number is here. This black part is the number of volumes. I think volume, some 24, 30, some volume. This is just one case. You think you can effectively argue or judge this case? You think you can? Then the other question is, if this is stored in the computer, then do you think you can judge? You can. Why? There are other tools. You can flag, you can bookmark, you can identify, you can separate. There are lots of other things. Now you can search. Now every one of us know the internet is very vast. Everything is there. But when we want to find something, you don't have to start from top to bottom in the internet. You just search and you get it. Now, however much is the volume, it does not matter in digital platform. Now, that is the point I am making. And although there was no answer from the audience, if you digitize this, if you take it to the computer, definitely you can. Because the tools are available. Those tools are not available in physical record. And for the lawyers also, it's very easy. Otherwise, how many? I don't know, Mr. Vikramanayaka, whether you have a lot of juniors. I know whether even you employ all these juniors. I don't know whether you will get anywhere. But it's not the case in the computer. No, this happened 2 weeks ago. That's the other point I'm making. Now this, about 2 weeks ago, this came up in the morning at 10 o'clock. And President's Counsel, Mr. Milinda Gunatilaka said, this brief is 8,000 pages. Brief is 8,000 pages. He made just one application. He wanted to tender only one brief. And depending on whether others come to court, he said with the difficulty he will create other briefs and send. So I asked, I think Justice Samyavardhana was on the bench, Justice Obesekar was on the bench. So we were discussing with each other, and then I asked how much you spent for this. Then he turned to his instructing attorney who was behind him, and then got that information from her and told 125,000 per one page. Then I asked how many respondents are there, 14 respondents. So 14 into 125 is 2 million something, almost coming to 3 million. So then we allowed the application and then went ahead with the other cases, and then came the last case around 1 o'clock. Then Mr. Nisam Karyappa PC was there. he got up for his case. He had nothing to do with this preparation of briefs, but he had overheard this conversation. He said, my junior told me during the sessions that only 1/3 of this photocopying cost is the cost for scanning. And he also said we are saving 2/3 out of it. Then I said, no, that is wrong. You are not only saving 2/3, because 1/3, that is about 33,000 for one page. Now, in the 125,000, 1/3 of 125,000 is about 30,000 or something. So multiplied by 14. Multiplied by 14. So I told you the figure about 3 million. So instead of 3 million, you only spend, let's say 35,000, 35,000. The moment you scan and get it into the computer, you can replicate any amount of responders. Day in and day out, applications are made to us on the basis that there are, like police promotion cases and other promotion cases, there are about 500 responders. So each respondent has to be given a brief. So people, it is not easy. That is one reason why people are reluctant to litigate. And with this system, it's good on the purse of the litigant, it's good on the purse of the counsel. Then people can litigate more. This is what is known as access justice and nothing else. There is no point in our talking about access to justice on these stages without doing that thing first. Some courts have already started digitalizing. I think this is Moratua, in their own way. But this is not sustainable for the same reason, for the reason that they have devised on their own individually, and they are operating, including Commercial High Court. Commercial High Court also has some kind of case management system, but it cannot be connected to the other system. It cannot be connected to the JC. I cannot have access. So they are operating independently, and because of that, there is little or no productivity, other than that to that court itself. So that is not the system we have in mind. We want to digitalize everything under one roof, and then interconnectivity. All are interconnected. Now I told you about this criminal case. Once the summary inquiry is held in the magistrate's court, it will be transferred. That digital file will be transferred to the High Court. There is no paperwork, and also I'm sure you all know very well that particularly in Commercial High Court, once a judgment is taken, you just can't enforce, because the other party, losing party, will appeal. Then how long it takes to prepare the appeal brief? Almost 10 years. Nobody knows where this case is. Unless and until it comes up in court, then only we will know that there is an appeal. Then only we see his number, SC appeal such and such of 2012 or 2013 or 2014. That is the time we see for the first time there is an appeal. Why? Because the system is not there. It is controlled by a different regime in the registry. We don't know what is happening. It is practically not possible for us to go into each courthouse in Sri Lanka and find out and go behind everybody. But once you achieve this digital transformation, either me or the JSC or any other authority will be able to monitor all courts from Colombo through the computer, and that is what is happening in the other countries. Then we know whether the statistics have gone beyond control, or whether you need to open up another courthouse, whether there is less case and you need to close down the case, etc., etc. What about the time? 5 minutes. So these are some of the these are some of the benefits. I think I have covered all that. This time attorney at law enrollment will be totally paperless. Totally paperless. So they have been given digital signatures also. I think they have completed registration for digital signatures. So they will come to the podium and take oaths and sign digitally this time. No papers are accepted. Everything has to be transmitted to our web portal from the law college. That we have achieved. And also, I think 5 President's Council are taking notes in November. We are going to do the same thing for them. They will also be given digital signature. And I said about e-filing, so lawyers also will be given digital signatures. And we will arrange that at possibly at provincial level. But there is a system online also, which has not been Lanka signed. They told us it has not been made available yet, but in about month's time they will make available. So online, even those who are in Kalutara, Jaffna, Kandy, everywhere, can access it online and get the signature, and they charge around some 3,500 or 4,000, and with the annual like a licensing fee, 1 or 2 years, 500 rupees or something. So that you have to pay and get the digital signature. That will be your signature, and that is the thing that you will sign with the filing. Yesterday also, I think Justice Samewardana mentioned about email address in the commercial law panel. Email address and people, that was the law in 2017, I believe. 2017, and nobody takes care of it. And he also said there is a phobia. Email address, lawyers need to put it in the proxy email address. So what is this email address? And just think why it is called email address. What is this address? Numbers such and such, that road, Watapulua, Kandy, something. So this is e-address. So that is to which we must travel, not to this Watapulua address. So people are asking then, oh, what is this email address? Why it is there? You need it for this purpose. Now that is the infrastructure, digital infrastructure, which has been made available by the government. And we just don't take it. Then there are, I'll finish soon. Since I have to hand over the podium, government has agreed to release money. The money we have asked for, this project. We will do that within this term, at least 50, 60 courthouses, and the rest next year. So my time is up. This is what the digital transformation that the court system is going to give you. Get ready. Thank you very much.
Thank you, my lord. I think the takeaway is that volume does not matter when it comes to digital cases. With that, we are now going to have the pleasure of listening to the National Advisor to the President himself on digital economy. Dr. Hans, I remember you were always available for law conferences, way back from even 2018. No, I think 2008. So Dr. Hans has always agreed to come and talk to us about digital transformation. And this is important because our lives are going to be affected. If you remember in 2022 what happened, just like that, we need to ensure that we know what's going to happen. Because if we don't, the repercussions would be severe. Okay? With that, I'm going to ask Dr. Hans to inform us or to educate us on the digital economy.
Your Lordship, Honorable Chief Justice, Honorable Justices of the Supreme Court, the Appeal Court, President, Bar Association of Sri Lanka, learned counsel from Sri Lanka as well as India, distinguished invitees, ladies and gentlemen. Aiboan and a very good morning. So this morning, I would first like to thank the organizers for the honor and privilege granted to me to share a few thoughts on the digital economy and in particular the backdrop of a trust environment which underlies and gives strength to the digital economy as it's accelerated into the future. So what is a digital economy? I'll give you a quick summary just to put this in context, and His Lordship already put it in very basic terms. It's productivity, it's outcomes, so costs and revenues of the economy. You bring costs down, increase revenues, and that grows the economy. Now, the digital economy is a subset of the macro or total economy, and in Sri Lanka, we are at around 3 to 4% in terms of the component of the digital economy. India is at around 12, developed countries are 25, 30, 40%. So we have a long way to go. However, the interesting point here is that international example has shown that as you accelerate the expansion of the digital economy, as this bubble expands and the faster it expands, the higher the uplift you get on your macroeconomic growth. And I think intuitively it makes sense that if we very rapidly make things efficient, the economy will grow faster than it would normally grow. So what is then the digital economy? What would make it grow? There are 3 tiers. Basically, the first tier, the narrow definition of a digital economy is what we do day in, day out, make a few payments through digital means, consume communication services, consume broadband, connectivity, etc. The second layer of the digital economy is around the platforms like e-commerce or ride-hailing. It's called a platform economy, which also adds a lot of productivity, as we all know from our day-to-day lives. But where you get this very rapid expansion of the digital economy and therefore the uplift in your economic growth is if digital means, digital methodologies, and digital raw material, which means data, digital raw material is data, the more you use it in all sectors of the economy, both industrial sectors as well as service sectors. And for instance, as His Lordship spelled out, the court system alone and the justice system, if digital means penetrate or invade this sector, the productivity gains to the whole economy will be very sizable. So our targets also reflect government's commitment, the investments that will be made, not only in the digital ministry and its organs, but across the economy for digitalization. We are aiming for a 5x growth in the digital economy, that is taking it from that 3-4%, which is in dollars around $3.5-4 billion today, all the way to over $15 billion in the 4 to 5 years ahead. So this is a 5x growth. Within that, the 3x growth in digital exports means software and services, digital products, to grow that whole industry, growing on our talent, a 2x growth in the digital workforce, and a 25 percentage point improvement in all the digital indices. These are the benchmarks that are available across different sectors and as a whole for the economy between Sri Lanka's digital economy versus other countries. So what are the principles underlying a digital economy strategy? I mean, there's no fixed set, but just to keep things simple and short, we've crafted this set of fundamental principles. Trust means that every institution, every citizen, every professional, every individual has to trust digital methodologies. The experience that citizens and businesses enjoy when dealing with government or when dealing with a counterpart in the private sector should be such that that experience is delightful. Now, in the government sector, we seldom, I think, increasingly, we try to do that, but it's not a day-to-day KPI where officials are measured for the experience that they deliver to citizens or businesses. This is a bit different from the private sector, where consumer experience, customer service, and customer satisfaction is one of the key KPIs, for instance, of a CEO. Inclusion, make it available, applicable, affordable to everyone. And I think that's exactly what His Lordship was talking about as well, that you need to enable justice for all. That would mean that effectively the affordability, the availability, applicability, and the affinity with which people could access the justice and court systems should be inclusively comfortable and a delightful experience. Return on investment and, of course, business models for all the investments that are made. Now, these translate into some technology principles, and I won't bore you with these, but in summary, we need to think about security and trust by design. Means that it's not an afterthought. As systems are developed, cybersecurity, privacy, and other edicts of data protection should be built into systems through the design itself, so that you don't come later to bolt the doors. You design your system so that they already have those protections. X first, AI first, cloud first, mobile first, so that your systems need to be very comfortable with an AI sitting on top of it, on cloud for storage and computing, and of course the mobile device for inclusion, because every single citizen has a mobile device. Openness and horizontal, meaning that whatever systems are developed, they should be open, not vendor locked, not restricted to a particular technology or vendor, so that you have to go back to that vendor over and over and over again. That is built on application programming interfaces, which means you have those plug points for multiple systems, multiple vendors, the development community locally and globally to plug in and innovate on top of these systems. So the horizontal and interoperable nature spells out the requirement for consistency and compliance to certain standards and directives. And when it comes to data, data should be federated, means that you don't attempt to bring all data to a single place. That creates a vulnerability. From a cybersecurity point of view, it also is against the principles of data governance that are practiced globally. Minimize data. Don't ask for data which you don't really need, and certainly don't ask for the same data multiple times, and whether it's a business or an individual. So His Lordship mentioned these multiple copies. I think that's a very good example of the principle of the requirement for data minimization, because data could be a document, data could be simply some information. And these principles have to also recognize ultimately that the world is moving in the direction of governance and trust taking precedence over cost, arbitrage, and automation. Meaning that investments globally and the flow of business confidence is moving in the direction of trust and governance. So if Sri Lanka can stand up and say, we have the best digital trust environment across the courts, across the justice system, across business interfaces, that in this whole region, then that is the calling card that investors would follow. Not so much that we go out and say we have the cheapest labor or we have the cheapest programmers in the world. That is no longer important. So I'll take you very quickly through the multiple layers of the digital economy blueprint, and then I'll accent where trust and other principles of digital governance come in. So at the bottom layer of the digital infrastructure is the digital infrastructure, components which we are very familiar with, the connectivity, your mobile networks, your fiber networks. On top of that comes the cloud infrastructure, the Lanka government cloud, which will be advanced into what we call a multi-cloud environment, which mixes resident cloud, meaning infrastructure in the country, with the hyperscale cloud, the AWS and Azure and Google clouds. You have a mix so that your data classification policy can guide you on where to keep the data, locally or in the public cloud. On top of that comes the cybersecurity infrastructure, like the National Cyber Security Operations Center, the various sectoral cybersecurity operations center. There's a FinCert, for example, for the financial sector. The telcos have their own cybersecurity centers, etc. Threat intelligence platform, CTIP, and incident response infrastructures for cybersecurity. Now, the sectoral piece of this blueprint, in fact, Sri Lanka is fairly advanced in its sectoral digitization. And here we have the justice system and courts, for instance, already well on the way. And there are other sectors also who have advanced systems. But we all know that the problem in Sri Lanka is not so much the state of digitization in individual institutions, but the fact that the horizontal layer, the interoperability, is very poor. So these sectoral systems don't talk to each other. And the result is that the citizen or the business dealing with government needs to go to multiple points in the chain. So what we really need to do is to introduce this digital public infrastructure, the cornerstone of which is the digital identity, and has many other infrastructures or soft infrastructures such as the digital signature. His Lordship mentioned that already, the electronic locker, the e-locker, the verifiable credentials. This is an interesting one where any certificate, for example, the certificate of an attorney or a counsel, could be digitally signed and available on his or her phone, so that in submitting a document, you just attach your digital signature and your professional certificate, which is also digital. So just an example. Now, this layer comes in between the physical infrastructure and the institutional silos to create interoperability and to enable developers to use the application program interfaces which are exposed by the underlying infrastructure to create multiple solutions. And this is our hope, that given a very short timeline of 4 to 5 years, whereas India did a great and wonderful job with digital transformation, but from 2013 to where we are, so it's like 12 years. Singapore, 2010 to now, 15 years. And we are trying to do all of this in 4 to 5 years. And the only way we can do that is using this principle of digital public infrastructure which runs across and creates that interoperability and innovation ecosystem so that our IT industry can develop multiple solutions for all these sectors. Wrap this around with a very firm emphasis on inclusion, on trust, on building the right policies, legislation, and institutions, and also on capacity building, training all the people who are involved in this ecosystem. The red marks here are those areas related to trust and governance, the cybersecurity, privacy areas, digital rights, the digital, the data protection authority, the PDPA, etc., and etc. So this can be painted with the key elements of trust which will underlie the functioning of the overall digital economy blueprint. Sri Lanka actually has a very mature trust environment, and I would rate Sri Lanka's trust environment certainly in the second or first quartile in many, many areas. But with increased digitalization, we also create increased exposure surface areas, and therefore we need to build in the newer laws and updates to existing laws such as the Electronic Transactions Act, the Personal Data Protection Act, which is now fully in place, and also new pieces of legislation as well as governance instruments for AI, for cybersecurity, for APIs and data sharing, and of course digital economy governance overall. Now, data governance, I believe, is a very important concept because it drives adoption as well as trust. If you have strong data governance, the services that are delivered to an individual or a business can be personalized. They can be proactive. And the experience of the citizen or the business is superlative in that situation because you're given proactive service and personalized service. It's inclusive and also would reflect evidence-based decisions because you're using data, you're using science, and therefore citizens and businesses dealing with authorities would believe and trust the decisions because they are based on evidence. And also, data minimization and interoperability becomes possible. Now, this drives adoption and trust and is very important with respect to the public sector transformation because adoption and trust become foundational to a policy which is AI first and cloud first, and supported by data privacy, cybersecurity, digital rights, and the ethical use of new technologies. These are a whole family of policies, guidelines, rules, which we will need to develop to deliver trust and ensure trust of the citizen and the institution. However, there are conflicting regulatory imperatives, and I'm sure the audience here would be very familiar with these conflicts. On one hand, you need to keep things secret. On the other hand, you need to be transparent. There's a compliance burden, and there's a requirement to deliver citizen trust. Technology is expensive, and do you have the budgets to drive this kind of technology and data governance environment? Therefore, we are called upon to apply proportionality, to apply context awareness, and be conscious of local needs. We also have to be aware that we need to allow innovation and build systems which are future fit and follow global trends. So the task of a regulator, the task of an authority is becoming extremely difficult. And I think that's where there has to be forbearance, there has to be tolerance on the task of the regulators of the future. This is augmented with respect to AI, where there are multiple risks, such as profiling risks, self-learning risks, even the fundamental risk of false inference. And therefore, we also need to look at moving from explicit regulation of, for instance, AI and its use to a risk-based or proportional approach. It has to be innovation permissive, and it has to be sensitive to the institutional capacity which we have to govern and regulate. Goes down to also the use of data and how we consider data. And I think this will be an important concept across all sectors. Data can be open, meaning public data. And for the development of a digital economy, especially the competitiveness of a nation in the global context, we have to make as much of our data public as possible. Because if you really look at it, nearly everything, there's nothing too secret unless it's really personal in nature. So our institutions need to be open to making data public for AI models to learn on them and deliver better outcomes. Also, data can be classified, meaning permissioned or constrained data, and classified from low to high levels of risk. Accordingly, you can also have definitions of structured versus unstructured, secured, anonymized, or even synthetic data, artificial data. Artificial data which is representative of the patterns of real data, but are not real data, and therefore can freely be used by AI models to train themselves and deliver tasks. Now, the paradox is that when you apply these data classifications to the reality of data, the costs of data manipulation and storage, you will find that the public cloud is more secure, is more innovation permissive, and cheaper, whereas your resident clouds are more expensive, less secure ultimately. However, you have the comfort that you have the data in your country. And of course, the small country challenges persist. We have a small population, a small market, and therefore big tech determines that we need to rely on them for our data tech, reg tech, regulatory technologies, fraud technologies, cyber technologies, privacy technologies. And can you tell the largest behemoths in the cloud space, you have to come and install in Sri Lanka, otherwise we won't use you. They'll say, okay, and they will not come, and, or rather they haven't come yet. We are trying to create the environment for them to come, but we need to be aware that there is a tech polarization. There is anti-competition at a global level. AI infrastructure, for instance, will be controlled by a few. Now, how do we get access to AI infrastructure and sovereign AI infrastructure to help Sri Lanka have its own sovereign domain in the AI world? So regulation without overreach, given these various factors to balance costs, sovereignty, the realities of tech polarization globally, we need to follow what I would call a soft law approach driven by proportionality, to leverage and adapt existing laws, to adopt risk-based approaches, and move from voluntary compliance to formal compliance through moving through codes, guidelines, and laws. So we have to tread carefully and sensitively into the future. We have therefore an overall challenge not of technology but of a whole of economy change management problem, to simplify the processes, to have the right mindset and culture of change, to focus on the service to the citizen or the business, and to be agile ourselves, every single one of us, to be agile in our approach to the new opportunities and challenges. I'll end with talking about the super ROI, the super return on investment. We operate as a country in a very tight fiscal space. We have recovered through an amazing effort from an economic crisis, but we don't have the fiscal resources to throw behind growth. Normally, you would invest in order to generate growth. We cannot do that. And it's digital, I believe, which will give us the productivity, which give us the uplift in profitability at a national level, so that we can achieve our growth without spending too much on capital investments in the next few years. Thank you very much.
Thank you, Dr. Hans. Now, the Honorable Chief Justice mentioned about 8,000 pages and the cost of photocopying that. From that, Dr. Hans picked it up and showed us that in the future, everything hopefully will become digitized and we won't have to pay for any photocopying in the future. With that, Dr. Hans also mentioned for this process to take place, we need data. The data is the digital goal of the future. Is there anybody here who is willing to give their phone for us to go through? Is there anybody who is willing to take that challenge? I don't think so, because those are our personal information. There are things that nobody else should know. So with that, I'm moving on to Dr. Tusita Abesekara, a brilliant and leading academic with regard to data protection. Doctor, may I invite you?
Its Lordship Chief Justice, Honorable Judges of the Apex Court in Sri Lanka, other judges of the courts in Sri Lanka, President of Bar Association, members of the legal fraternity, and members of the legal academia, ladies and gentlemen, everyone, good morning. This is the topic being given for me to discuss under the title, a theme, Digital Roadmap for Sri Lanka, the Way Forward. So it is better to identify first what the data is. As Dr. Hans correctly mentioned, data is the digital raw material. Data can be divided in several categories, popularly data and information, where data is raw material, information is processed data. Especially in communication, data can be divided in several categories, basically two, content data and metadata. As its word suggests, content is the message. The metadata is the data about data. subscriber information, who send the message, sender's information, receiver's information, duration of the call, duration, time of the call, date of the call, those are metadata. Those points are very pertinent in our law. For example, under the Section 8 of the Computer Crime Act, we discuss communication including both content data and metadata, and it is a punishable offense. This Section 8 intercept communication. Not only that, Section 53 of the Telecommunication Act in the same position, but only consider the content of telecommunication. So these terms are very noticeable in our law. This is the most important category in data protection per se. Data can be divided in three categories such as data, personal data, sensitive personal data. Personal data basically means data that can be used to identify a person. Sensitive personal data, actually there's no precise concrete definition for the term, but there are possible lists on what possibly can be considered as sensitive personal data. When we come into the Sri Lankan version, under the Personal Data Protection Act number 9 of 2022, Section 56 interpretation clause interprets the personal data as any information that can identify data subject directly or indirectly. Directly the name, for example, indirectly nickname, or any type of identifier such as again name, identification number, location data, online identifier, or any factors specifically address the the psychological, ethical, economic, cultural or social identity of that particular person. As a country, as a nation, we are ready to protect not only the living person data but also deceased data. Right? Again, under the Section 56, we do have a special category, special categories of personal data, which is very similar to the sensitive personal data in international level. All the data protection laws finally focus into the point of privacy. Privacy is a right, where really it is a fundamental right in some jurisdictions, and it is a right at international level. For example, Article 12 of UDHR, Article 8 of the European Convention on Human Rights both define and confirm the privacy as a right, but none of them provide the definition for the term privacy because it is really difficult to define it. It depends on so many things such as the particular person, his living pattern, his personal perspective, cultural perspective, religious perspective. So all of these documents are silent on interpretation of privacy. In academic perspective, actually two academics in 1890 suggested a possible definition for the term privacy, that is right to be let alone. Right to be let alone. However, at this moment, luckily in Sri Lanka, we do have a precise, good level of interpretation for the term privacy, not under the Data Protection Act, but under the Online Safety Act. Section 20, while confirming the communicating statement to cause harassment, under the subsection 2A of Section 20, clearly define what the private information is. So private information means personal information including any image, audio or video details that, this is the most important part, any person may reasonably expect to remain private. So the honorable judges at the courts, they are not going to decide what is privacy. The governmental institution, that they are not going to decide what is privacy. The particular person, he himself decide the privacy. So it is very comprehensive, broad interpretation given by Online Safety Act. Actually, privacy, the protection of privacy is not a new or modern concept in Sri Lanka. We have been with this concept for a long time. It is date back to the Roman Dutch law application. Actio injuriarum, as you all are well aware. All defamation cases are challenged through actio injuriarum. Concern the privacy. Postal ordinance in 1908, under the section 75 of the same, after we drop a mail to the mailbox, there are only two people who can open it up, receiver or postmaster general. We protect the privacy. Banking Act in 1988, Telecommunication Act 1991, Computer Crime Act 2007, Right to Information Act 2016, Article 14A(1) of the Constitution. We have taken so many steps to protect privacy. I will show you some practical examples from UK where they confirm what the data protection is. Actually, this case was the high profile case at that time, 2017, various Clement versus W.M. Morrison's case. In here, IT director of this company, who was expelled by the company on that date by using his own computer in his own residence, he accessed to the payroll data of the company, took it out all the data from the server and released some of them to the dark web and sold some of them to the third parties. Representing 100,000 employees, 5,518 employees took a legal action not against the director but against the company. Vicarious liability. They failed to take necessary steps to protect their data. So there's a good lesson for us. When we take such type of decision, at the same point we have to change all the credential, security data. And UK court, they confirm that it is a data violation. Another interesting case, Anthony Woolley and Deborah Woolley versus Nahid Akbar. A person installed a CCTV camera to record the access point of his residence. Because of the technical point of the installation, the camera recorded automatically some part of the road as well as the access point of the neighbor. Neighbor took a legal action against the owner of the camera. He did not register his camera with the Data Protection Commissioner. Court decided that it is a violation. These two cases are very similar with the detail, the facts. Actually, it is a very dangerous software. Imminent Monitor RAT. This person, actually two persons in two cases, they sent that software to three women who are living in a room. Without knowing the technicalities of the software, they accept the message. From that point, the sender can control the camera. In this way, he secretly filmed their things inside the room. In these both two cases, the court confirmed that it is data protection, data violation of the data. Now we can come into the Personal Data Protection Act. This act, first time in Sri Lanka, create a right, data right. Now it is right in Sri Lanka. By introducing Right to Information Act, we created a new right in Sri Lanka, access to information. Access to information is a right under the Right to Information Act. And the Personal Data Protection Act number 9, 2022, data is a right. And there's a very interesting point in here under the preamble of the Data Protection Act. So keep in mind, this is not the law to protect only the personal data or data subject. This is a balancing tool. This law is going to balance two notions, strike a balance two notion in two sides. One side, digital economy. On the other side, personal data. It is clearly mentioned in the preamble of the Act. It is necessary to facilitate the growth and innovation in the digital economy in Sri Lanka whilst protecting personal data. At the end, it is again mentioned that this law provides necessary mechanism for the protection of personal data of data subject, ensuring consumer trust on one side. At the other side, safeguarding privacy. Actually, when we are thinking on privacy, we don't want to engage with digital economy. We are reluctant to engage with digital economy. This law invites people to get into the digital economy. If there is a matter, law is there to protect you. This is the law to protect you. Personal Data Protection Act. As I said earlier, this act creates a new right in Sri Lanka, that is data right. When we consider the data right consists with 4 different type of rights. View, review, not use in direct marketing. View. A data subject, data owner has a right to view his own data. For example, think a person create a data bank, a CV bank. I noticed that my CV is there. It doesn't matter for me, but I can make a request to him. Can I have a look on it? View. The second one, review. Where recently I got through my degree. It is not there. Then I can make a request to them, change it accordingly. If they are not in the position, I can go to the courts. Review. View, review. The third one is not use. Not use in any way that may potentially, not direct, potentially cause damage or distress to the data subject. Last point is very interesting and very popular, not used for direct marketing. You might have seen that, you might have this experience, especially at the Pizza Hut. What is the first question? Do you want to eat pizza? Do you have any money? Do you have any preferences? No. Do you have, sir, telephone number? They collect the data and they use the data without our authorization for direct marketing purposes. Now we do have a right to say not use my data for direct marketing. So data right consists with 4 different type of rights: view, review, not use in direct marketing. Application of this law in Sri Lanka. This law applicable to the place where the processing of personal data takes place wholly or partly within Sri Lanka, or where the processing of personal data is carried out by controller or processor who is living in Sri Lanka, domicile or residing, or any institution incorporated or established under any written law of the country, or any person offers goods or services to data subject. This law is applicable. Specifically, this act says under the subsection 5, if a controller or institution monitors the behavior of data subject, this law is applicable. Now it is very popular concept that loyalty cards. By giving loyalty cards, what they are doing, issuing you discount? No. They are collecting our habits, expenditure habits, buying habits. Credit cards, while providing plastic money, they collect all expenditure habits. It's a big data. It is not a wrong thing, but they have to do with this in a manner. Quickly, I will come into the point. The controller and processor, this act creates a lot of responsibilities on the shoulders of controller. So it is important to identify who is the controller. Controller, right. Controller means in here a natural or legal person along or jointly with others, determine the purpose and means of the processing of personal data. Processor is the person who assists the controller to do so. Right? This act creates a new responsibility that every controller should have data protection management program. And every controller should have a specific office data protection officer. He may be an inside person or outside person according to the new amendment, right? And there are several steps that need to be taken in order to prepare a data policy. So these are the steps that need to be taken. First, perform a risk assessment. Based on that, you can prepare a security policy. You should have a security policy, and that is the word they suggest for the security policy, data protection management program. There are 8 different type of principles in data protection. All these 8 principles are represented in our act from the section 5 to 12. Section 5 and 6 represent
Dr. Abhishek, I think we'll have to wind up with this, but in the Q&A, we can come back to it.
Okay, thank you.
Thank you. So, from data, the digital gold of the future. Now, that all these documents are going to get digitized, then it will be shared. But what happens when you have data all over? Can the data, or is there any dangers of having data? Now, for that, we have invited for the first time in a national law conference, Mr. Asela Vaidya, who is an expert and one of my gurus for cyber security, and he's going to talk us through the future challenges that we will face in a digital economy. Over to you, Mr.
I thought I'd take a different route rather than showing a lot of text on screen. I'd rather keep your attention for a short time, and I promised Shehan that I'd keep my remarks short to make time for the Q&A, which I think is important for everyone. His Lordship and distinguished members of the panel, distinguished members of the Supreme Court, President of the Bar Association, eminent President's councils, foreign dignitaries, invitees, friends. When a judge in Brazil was recently advised not to rely on ChatGPT to draft a judgment, yes, it happened. It was not a rejection of technology. It was a reaffirmation of humanity. It reminded that while machines can accelerate our decision making, justice must remain a human art, one guided by our conscience, and surprisingly for someone like me to say, not by code. This anecdote that I shared with you captures the challenge in front of us today of how law, our most human instrument of reason, will coexist with technology, our most powerful instrument of change. As we gather to discuss this particular theme, I think it's important to reflect on that particular question and statement. The 21st century's legal order will not be measured by how efficiently we automate, although that is absolutely critical. We must also faithfully uphold justice in the algorithmic age, which is important. It's supposed to move, but it isn't, but it's fine. Cybersecurity and cybercrime particularly is a $10.1 trillion industry. Not million, not billion, trillion. And that is for this year. It is expected to grow year on year. Just to give you an idea, the entire debt of Sri Lanka is about 56 billion US dollars. I always tell my students that's about 3 days of cybercrime if you do it right. However, I am not advocating that in this esteemed forum. Cybersecurity today is not merely a technical discipline. It is not something that should be in the server room. It has now gravitated towards the boardroom, and I hope that I can urge all of you all to think about it in the courtroom. In essence, it's actually the constitutional foundation of the digital state. So therefore, every breach, every compromise erodes not megabytes, but indeed public trust. So in that sense, it becomes very important to our democracy in the digital age. And therefore, it is very important for us to rely on legal instruments, maybe not even here, to ensure that we are aligned. Because one thing I want everyone to understand is cybersecurity and cybercrime in that sense is a cross-border crime. I urge even the policymaker to relook at our Computer Crime Act. Although it is good and solid in its foundation, it is crafted at a time where we looked at cybercrime as something that can happen within our jurisdiction. It is not the case anymore. The cyber attacks that you face are perhaps orchestrated in another country. This is where cross-border cooperation, cross-border investigations, and legal instruments or international legal instruments like the Budapest Convention on cybercrime are important. I'm happy to note, the Chair has informed me as well, that Cabinet recently made a decision for Sri Lanka to be a signatory to the United Nations Convention on Cybercrime. This is a long-standing convention that was debated several times because we need to have an instrument for cybercrime. So I'm happy that is happening. But this is the future. Sri Lanka also has to align ourselves to these instruments to make sure that we are indeed present when we are in our digitization journey. Dr. Hans touched on that aspect as well as his lordship. Now, I present to you, because I was asked to look at some AI parts as well, how artificial intelligence is transforming how our decisions are made, and I'm sure everyone here agrees on that. Algorithms now are entering our social lives, our economic lives, and of course, our legal lives. And with them, they're bringing profound ethical dilemmas. Who is accountable when the machine errs? What happens when justice becomes a black box? So I'll give you two examples from actually the United States. One is State versus Loomis, that's in Wisconsin 2016, where a defendant was used a system called Compass to give his, to grant him bail. And he was given a particular risk score. Now, court upheld its use, but cautioned that opaque systems threaten due process when defendants cannot examine or challenge the logic behind it. And I think this is a very important conversation we will continue to face as we digitize the process and the algorithm. The decision making that is being used is not clear to us. We are only clear about the output. In Houston, Federation of Teachers versus HISD, again 2017 in Texas, teachers were fired based on an algorithm. They were given a performance review based on an algorithm, and based on that algorithm, they were fired. Court found that this violated procedural due process and underscored demandness for fairness and explainability. Now, all of this points to some same conclusion. When law loses sight of the logic behind the automation, automation is critical. I do not argue I do not argue against it. The rights are at risk, and the rights become collateral damage, and that is something I'm sure all of us need to be sensitive on. Now, AI in the legal profession, as you all are aware, is a force multiplier. Legal research, contract review, case analytics, everything we use it for. And I'm sure you are using it right now. However, there are ethical questions that come about doing that. We do not want artificial intelligence to be an accelerant of error. A stark reminder of this was given in Malta versus Avencia, where lawyers generated AI case citations that turned out to be fictitious. The court sanctioned them, sending a very strong signal. Compliance now includes understanding and verifying, Your Lordship, the outputs. Across jurisdictions, a similar sentiment has been echoed. I take the example of California. You may wonder why California, because most of these tech companies are based in California. So when California gives judgments, it's very important for us to be attuned to that, because that signals the global precedent. And in California now, law enforcement officers are not permitted to use generative AI to generate investigation reports or reports related to disciplinary inquiries, simply because there is a concern about bias and hallucinations from AI systems. Brazil mandates that all AI systems used in courts must be registered, auditable, and importantly, explainable. So there are international instruments in this, and I've had a conversation with Dr. Hans also on this. The Council of Europe has an AI treaty. EU AI Act is a hard law. There are other global treaties such as the Hiroshima Process for Trust and Transparency that's built around the G7, the OECD, ASEAN, Latin American countries have the Moldova Declaration, and of course the African Union has used their declarations where they rely on the similar concepts. So all of the global countries are taking certain steps to ensure that AI has certain guardrails and red lines, and rightfully so. Now, as legal professionals, all of you, you bear 3 duties in the age of AI. One is competence. We must understand these tools. And of course, more importantly, what are their limits? What it can do and what it cannot do. And candor. Candor is to disclose that you are using these tools not only to your clients and perhaps sometimes to courts. There is no problem in using them, but you must be transparent about its use. This is the same position I think academia has now taken. And supervision. You must ensure human review before you do reliance. Now, in closing, as I said, I will make time. Every courtroom, there is one invisible presence. And that is public faith, Your Lordship. It is built on, not efficiency, but explainability. So as we architect the next generation of justice, we must ensure that we encode transparency and fairness into our digital systems, as much as we did so deliberately, liberty into our constitution. The integrity of our digital future will depend not on the intelligence of our machines, but on the conscience of who governs them. However, if we can align these timeless principles, principles that all of you are trained on and aware, fairness, reason, dignity, transparency, then Sri Lanka will not merely become a digital nation. She will become a digitally just nation. Thank you for your attention.
Thank you, Mr. Vaidya. Thank you so much. You finished very early, so that you left a lot of time for us to hear across the seas. Now, the gentleman sitting next to me has 49 years. I think the 49th Chief Justice and the gentleman next to him has 49 years. And he told me that his first arbitration or international arbitration was he appeared in 1982. Unfortunately, that's the year that I was born. So he has 40 years of international arbitration experience as well. So with the wealth of experience, we are looking forward to Mr. Gupta to take us through the digitization process in India. Over to you, Mr. Gupta.
The second slide begins from the beginning. Honorable the Chief Justice, dignitaries on the dais, dignitaries of the dais, colleagues, lawyers, judges, ladies and gentlemen. Good morning, and thank you very much for giving me this opportunity to be with you. So the subject, I was slightly, the topic which I am going to talk about is digitization of Indian courts, the way forward. And picking up from what our judge, Justice Suryakant, who is going to be the next Chief Justice of India, he said, the South Asia Law Tech Consortium. Now, that is one thing where India and Sri Lanka can join together and create a powerful group so that we are able to lead the whole Southeast Asia. Now let me tell you, when I joined the Supreme Court, my father was a judge, so I'll have to leave the High Court and go to the Supreme Court because there's no choice I had. So after 10 years, I realized there were 4 issues that every lawyer was facing. One was that judiciary was practically dealing with aberrations in the society. Agreements were made, they were not made to enter into doing well, but the real concern was the split, the golden handshake. The agreements were not made for marriages, they were really made for divorces. How do you deal when the problem comes in? Now that is where the role of the judiciary came in. And for doing that, we have to carry out the heart and the brain surgery of the society. Now to do the heart and the brain surgery, we need laser guns, we need sharp tools. But that were not provided to us, and when we were arguing matters in Supreme Court, one of the major issues was to find out judgments on a particular section, to find out which judgment has been followed in which judgment. So there were almost like large number of law reports, and there was a mushroom growth of law reports, so it was very difficult to find out. Another issue which I realized was that there's a lot of R&D in medical, but there was no R&D in judiciary. And then by 86, when I got the first computer, I realized that transformation to digitization was choiceless. We have to move, and that was the time when the first book of Bill Gates came around, the Business at the Speed of Thought. So when I read through it, we started doing something on the judiciary. Now let us come down to what exactly we are looking for in digitization of courts. So according to me, when you talk about digitization, we are talking of a comprehensive integration of information and communication technology for every facet of judicial process. And I'm emphasizing on that thing, involving every stakeholder, and that is again important. Now this whole thing should be simple, secure, human-centric, with minimum cost and time, maximum predictability. It should deal with end-to-end life cycle of every case. And when you talk of every case, it is from complaint to Supreme Court. Then the outcome should be faster, fairer, traceable justice. And when I talk of traceable, it should be transparent, accessible, efficient, user-friendly, and accountable. Now let us go to the stakeholders. Now these are very important according to what I think is, because you see, when the computation really started in Supreme Court also, it was more of a judges-centric. And that was one of the major issues why it took a lot of time. Because, and I was very clear, and incidentally I had a chance to visit Singapore for doing a major litigation, so I made almost like 16 trips in 6 months, and that is where we were also working simultaneously on it. The involvement of the bar is one of the most important things for any digitization of the courts. Now when we see this picture, at the center we have a common man On one side, on the top, we have got judges who are making the law, who are not just, so when every judgment when they deliver, when they do, they make the law which is enacted by the parliament. So they make the law which goes into judgment and law reports. Then we have got media which is interested in breaking news, then government who enacts the statutes, the law colleges and academicians who analyze the judgments, then law students who are learning it, the advocates who want to make their client win and make submissions, and the registry which is processing. Now this is the whole cycle, but in the center of it is the common man who is a litigant. Now this litigant is looking for justice. And litigant, when we talk of corporates, businessmen are not interested in doing litigation. They want to do business. So their business is business, though maybe it is that lawyers have got their business is being into litigation. Now this is where I take you to the journey of the Indian courts, how it started. So in 1985, it was Justice P.N. Bhagwati who was the Chief Justice of India. Now let me tell you, and I'm very happy, let me concern about it, that all development in the judicial digitization has been done by the Chief Justices. So I'm really beholden that the Chief Justice of Sri Lanka has taken up that step, and I think it will be carried on and on. So it was 1985, incidentally, I had a talk with Justice Bhagwati when we got the digital LED boards installed outside each court to display the item numbers and the case number to be heard inside the courts. The display of boards are also, court number were put in the bar library and court corridors to help the advocates. Now this was a pioneer step to help regulate courtroom congestions, because that is one of the major issues, because lawyers have to wait till the next matter is called out, they have to see which matter, and then rush to the other court. And so it helped in organizing advocates movement, setting the first practical example of digital court management in India. Digital displays board were installed all over the country. Then 1986 was the process started for developing a digital database of Supreme Court judgments in Foxborough. That is where I was involved into it, which we gave to Justice E.S. Venkatramaiah, who was the then Chief Justice of India. He agreed to launch the judgment software, making the first instance of the judgment retrieval system of the Supreme Court. Then 1990, High Courts of Delhi, Karnataka and Maharashtra initiated early stages of computerization to digitize cause list, judgments of court records focusing remained limited to word processing, record indexing and cause of list printing. Now this is where the first part is, where we are transforming, and that is where I think the Sri Lanka is, transforming the entire data which was as your Lordship showed the records into a digital format. So that is the process which is started in 1990 in High Courts. And then 1996, that Law Information Center, of which I am the president, we launched the first legal website in India. Then a seminal paper was on digitization of judiciary was given in 1999, outlining the long-term vision of the ICT enabling courts in India, submitted to Supreme Court. Then, now this was a turning point. In fact, the year 2000 was a turning point where the Information Technology Act of 2000 was enacted by the Parliament, where providing legal recognition of electronic records and digital signatures, laying statutory foundation for e-governance and e-courts. Then 2000 to 2003, when I was in Singapore, I requested these people, Crimsology, who has done the entire judiciary software for Singapore. So they visited India, and then we made a presentation before Justice Lahoti, who was the senior most judge of Supreme Court. Then when Justice Lahoti became the Chief Justice of India, then on 5th of July 2004, he requested the Ministry of Law and Justice to constitute an E-Committee for computerization of courts. Then in 2004, again, the E-Committee of the Supreme Court, constituted by Justice Baruka, to prepare a national policy of computerization on Indian judiciary. And in 2005, the E-Committee submitted a strategic plan for implementing ICT in Indian courts. The plan emphasized on digital records, case management system, networking, because Ceylon is a small country, India is a vast country, so the networking of all the courts were very, very important. So that is where it started off. Then training of the judges and staff, I think, is the most important. And then the judgment data transparency. Then 2007, the Supreme Court E-Committee launched the National Policy and Action Plan for implementing of ICT in judiciary. Now the focus areas were district and taluka courts. So basically it reached to the lowest level. And then installation of hardwares, the LAN and the central case information system, online access to the cause list, case list status and daily orders. And in 2014, 14,000 courts were computerized though gaps in infrastructure and training persisted. Then 2014, a project approved by Justice R.M. Lodha, who was the Chief Justice of India. Then 2014, Government of India sanctioned a phase 2 to achieve a complete digital transformation of the citizen-centric services. At the end of the day, the center is the citizen. So they should also have an access to find out what has happened in their matter. See, every time they have to contact the lawyers to find out what order were passed and what are the various proceedings which has taken place. So the court that they were given access to the record of the case of the case, so they can find out what are the pleadings, what are the records in that case, how many orders have been passed. And then Law Information Center, that I am the president, we submitted a white paper on neutral citation, and that is what I am requesting the chiefs to hear also. You know, this neutral citation is a single umbrella in which the judgment is given, every judgment is given a numerical number. It is not based on the publication of the law report and the page number. This was started way back in 1997 when the American, who were the CEOs of the original American law reports, he retired and then he started on the digital, because he said in the web world, you can't wait for the judgment to be published. So this is where they started it. Then Canada adopted it. Lord Wolfe on 10th of January 2001, he made a practice direction, and where he said very clearly that this we'll start from UK SC. So you can, if you see the citation now, you'll find UK SC 1, 2, 3, 4, 5, 6, 7, 8. And till the last court, they have given a neutral citation to everybody. So in our courts, and the same must be here also, we have got orders which are daily orders. Then we have got proceedings. And the third is the judgments. So everything is given a numerical number. It's very simple. Like we can have SLSC 1, 2, 3, 4. And if there's a proceeding, we can write P in the bracket, and order it is, we can write O. So everything is, everything is structured. And nobody has to wait for publication of it. And one of the suggestions which I've been giving to Supreme Court also, that moment an order or a proceedings or judgment is passed, a copy should go to the advocate. Why should he apply for the copy? Now that is how you move the things fast. See, you don't have to wait on the technicalities which was created at one point in time by Britishers, that this has to be done, this has to be done. We are in a different world altogether. And something has to be, innovations will have to be taken place. So this was the one thing that we did. Now this was basically, phase 2 was the keystone. The turning points came basically for e-pay. Now this was very, very interesting, because there was also a problem of, we had a scam of somebody printing these stamp papers, forged stamp papers. Telgi was a big scam. And therefore they came out with an online payment system. So the e-pay, if you see online payment of court fees, fines and judicial deposits across 23 states, and 2.87 billion was collected. Then e-filing, now e-filing was actually the turning point, because for e-filing, every lawyer has to make a PDF of the documents of the pleadings, and he has to file it. And once you do it, then you go down the liquid text and you can search it faster. So that's one of the greatest advantage. But then then the problem came up that every lawyer can't afford an iPad. So then the issues again the economics of the lawyers is another issue. But then the whole thing started getting digitized. So you can use public libraries. The libraries were installed. We had stalls coming up where you can access your own data. And every judge, every case, every pleading which is filed in the court, right now it is very limited only to the lawyers, but I am still trying to say that everybody will be entitled to this. Ultimately it is a public record. Once the moment it is filed in the court, it is no more a private record, it is a public record. So people can download it. The submissions can be looked into by other lawyers as to what was the submission in this particular case. Then this was an interesting thing where virtual and hybrid hearing started and institutionalized during the COVID-19. Now, according to me, what I call the COVID-19 is a cosmic kick. The cosmos kicked the whole world into a digital world. There was no choice. We could not go out. So virtual hearings came in. And then live streaming of case came in. This was very interesting because if you see the original principle was that Queen's Court will never be closed. King Court's doors will never be closed. So everybody should have access of it. The live streaming, there's a lot of objection of a lot of people. I should live stream. But I am one person who supports the whole idea. I said it's all open. When anybody can see in the code, why can't he see it on his laptop or a computer? So live streaming was enabled, and there were judgments to support because people challenged it. Everybody has interest to challenge it, to show that. Certainly 2 minutes. The e-court services then launched 5.8 billion downloads, winner of the Digital Indian Award. The live streaming implemented in Gujarat High Court, National Data Grid stores now entire database. It was existing. And that is where the government support and the judiciary support, 210 million cases, which are earlier also, they were all digitized. Every records are digitized. And 240 million orders of the secured cloud. Because earlier there was a problem of hard disk and all. When we started, we used to use floppies, and then we went up to 20 GB hard disk, but now there is no issue on that. Then we got e-portals, free access to 39,000 judgments, and then now we are working on neutral citation. Then came up the introduction of paperless digital entry passes, because when the visitors want to go to the court, they have to take a visitor pass. So that came up. So there are 120,000 million is wrong, 120,000 entries. Then 713 plus districts on website were hosted. Then public facilitation for e-filing and payments came in. Then blockchain pilots came in when Telangana using blockchain for land records protections. Pilot project initiated for judicial record security. Then interoperable criminal justice system was launched. Then Supreme Court portal for assistance of court. Then Vedic Anuvad. Now this is one of the major things that can be used, is the translation. So you can translate from English to local languages. So we have got 16 languages, official languages. So now with the use of AI, it could be translated to all the languages. Then pandemic accelerating virtual courts and district court, the hybrid mode, I'm just skipping out. Then we gave another issue was subject index. So we had a hackathon. So the entire subjects have to be categorized. So now this is where the links are. What is taught in the schools, where the books are written, and in the law reports, what should be the major subjects. And then finally a statement of Justice Chandrachud came up, who was the Chief Justice. Technology is not an option. It is a new law book. Now this is for, again, 2024-25, we are moving towards a paperless and AI-enabled courts, where this is Vision 2025, it focuses on 100% digitization of judicial records. Then there's a Supreme Court pilot, AI judgment-based. And finally, I come to the final future vision, a digital-first judiciary which seamless integrates e-filing, live streaming, AI-enabled translation, and blockchain-secured records. One nation, one judicial portal. Now that is very, very important in the judicial world, that you can't have multiple people doing it. Ultimately, you have to do a single centralized system. So it is a decentralized situation with a centralized system. So it's a one nation, one judicial portal connecting all courts to Supreme Court. Because then from trial court to Supreme Court, you don't have to have 1,25,000 spending over 8,000 pages. Because that data which is originally generated in trial court can be transformed to the other courts, except for the new pleading, new ground, whatever added by the lawyer. So it becomes very easy. And then everybody knows what exactly it is. Then enhanced data analysis, then integration online dispute. This is what is now coming up, ODR. And I am a very strong profounder of what I call the online mediation. Because now, ultimately, we are not into mere dispute adjudication. The real is the resolution of the dispute using mediation. So this is, but it needs continual training of judges, staff, and advocates to sustain it. Now, coming to the last of my...
Mr. Gupta, can we wind it up? Because this is very interesting, but we need to...
Now for AI, I am just saying the AI and the advocates assist. AI and advocates assist. Judges decide, students learn, academicians analyze, and audit, and public benefits. So AI will not replace advocates and judges, but those who refuse to use AI will be replaced by those who use AI. That's the line. And then we can work on a South Asia, Consortium. These are the reports which may be generated using the AI for judiciary.
Thank you. So, we have heard all the panelists. Now, let's see what sort of questions you have for the panelists. You have the Honorable Chief Justice here, as well as all the panelists. Can we have some mics, please? So, we are looking forward for some questions. Can I see a hands up? Maybe even Chandra can proceed and ask one question. He's trying to bypass. Okay, is there anybody who wants to ask questions? Himali, would you like? I'm sure. Okay. Mike, please. Himali told me that she has some questions, so that's why. I think Dr. Hans, something's coming your way.
This is to Dr. Hans. We have so many laws. Would the government be coming with a new digital economy act, and how will you address the changes to other legislation that need to happen if you come with a digital economy act, and what are the changes that you would what are the most critical changes? Because Sri Lanka, we have several acts which deals with the digital arena. So then we have to see whether it overlaps or whether there is something that you need to do. If you can address that. Over to you, Dr. Hans.
So I'll first qualify my answer by saying that I'm not a lawyer. So, but our intent is, yes, the Digital Economy Act is in its final stages of pre-drafting, meaning concept-wise, and it will define an apex authority, Digital Economy Authority, together with the Digital Economy Council, which will be a cabinet subcommittee. But in terms of its ambit, the intent is to keep it strictly to the digital sphere and create a empowered institutional framework which can issue dictates on digital transformation and process transformation related to digital across the government, and the private sector also. Also to address key areas like dictates on process, cybersecurity, on the use of APIs, on data sharing, on various concepts that I talked about earlier. Will other legislation need to be amended? I think there'll be sufficient overarching or overriding language in the Digital Economy Act, but I know that in practice, this doesn't always work because institutions are always unsure, even though there is overarching dictate on certain things. So there would be a longer cycle of having to introduce light language, as in the requirement to consult the Digital Economy Authority, for example, on particular aspects of policy, strategy, rule making, where digital is concerned. But it will be a two-phase approach, the authority and the main act first, and then some amendments.
How do you address the changes to other laws? Because that will have an impact. Because you have to do it simultaneously, otherwise there may be gray areas and there may be more cases for interpretation.
Yes, you're right. I think the gap between simultaneous is the objective, but due to the time and effort it takes to do this, there will be a gap, and we'll have to address that, I believe, through good sense, because it's about the mindset. If you want to challenge which law is superseding, you can always challenge it. But if the sectoral mindset is such that we want to get things done, then you can go with the new act as the cover. When I look across, there aren't major conflicts because this is all in the interest of doing things faster, or it's not it's not bypassing rule of law. Therefore, I don't see many conflicts, but there are a few. You're very right in that.
There was a question from the audience, which I'll read it out. It was to Dr. Tusita Abesegar. Is this Data Protection Act in operation? If not, why is that? Doctor, can you explain why there was also an amendment suggested?
Yes, correct. Actually, it was introduced in 2022, and originally it was scheduled to be in operation 18th March this year. At the last moment, government took a decision to extend the date. Now it is in the third reading at the Parliament committee level. So it is not in the operation totally. So this is the situation. So it is in the pipeline.
When it comes, doctor, will there be a lot of things that our lawyers should pick up on? Like, will there be offenses and things like that, where maybe lawyers will have to consult or give advice as well? Can you explain on that?
Yes, of course. According to the Section 38 of the Act, it is a punishable offense. Non-compliance with any type of things on the Act, maximum 10 million rupees. So it is a punishable offense, not compliance with the Act.
From the lawyers, ICT, I know that there is a representative. Does she want to ask a question? Okay. Then I think I can ask. Is there anybody else who wants to ask?
Thank you.
Okay. There is a question.
I frame this question to His Lordship, our Chief Justice. Together with sharing some experience, my experience, my own experience in Nurli District Court and Gampal District Court. My question is, when we will be able to get soft copies of the proceedings and the judgments? And my experience is this. During the pandemic time, I proposed in a bench bar meeting to accept the written submissions by email. But it was refused because the judges are allowed only to accept oral submissions and written submissions in writing, printed version, not else. And in the District Court of Gampala, I went there with my written submission. I was asked to keep my submission on a chair made available in the sunlight outside of the court. But when I went there, there was no sunlight. There was a little shower. Then I asked to file my submission in another day, and I asked for postponement. I got that postponement, and I filed on the next date. Thank you.
Thank you for the question. You can obtain journal entries in the Supreme Court. That is done, and that is even from your mobile phone you can see that on the same day. Not only that, you can track your case also on a particular date when you generally at the inaugural speech also I said lawyers hop in and hop off from court to court, and it is now lawyers, a lot of lawyers are using this. So you know, you can track the case from the list how much far down, and then according to that time you can come. Well, I have to say, this other courts, you said you are in Gampala, it has not reached to Gampala yet. E-filing, Supreme Court also, it is not possible right at the moment, but in about a month's time, we have developed that thing we have developed, but not yet launched. In about month's time, it will be made available in the Supreme Court. And Court of Appeal, we have also developed in a similar time. In about a month's time, Court of Appeal also will be done, and then it will be there. In other courts, I told in my address that we have got money for 50 courts this year, this term. And Gampala, if it is caught up in this 50, it will be done in about maybe 1 or 2 months, within 1 or 2 months. Time period this is so quick because what is most difficult is to develop this system, the software. That we have done, we have finished. And it is the same system that we will replicate to other courts also. So we have done it to the Supreme Court, Court of Appeal, and the Commercial High Court. Then we have only about 5 courts. We have Supreme Court, Court of Appeal, Civil Appeal High Court, Criminal High Court, the District Court, Magistrates Court, and Labour Tribunal, just 6. So the same process, same software, which I said we have developed, with little bit of changes, because the categories of cases that are coming up in each court is little bit different. And the process also, district court, the procedure is different from magistrates court, and appellate process is different from that of other courts. That is the only change, which does not take time. So with those, and the Colombo, we have identified the Colombo Civil Appeal High Court, Colombo Magistrates Court, and they are doing it. They are doing those changes. Once those changes are made, maybe within 1 or 2 months, it's a matter of copying that and pasting in other courts, firstly. Secondly, you must have a set of computers and the networking facilities, which also will not take time. So that's a time taken for the procurement, time taken only to fix the networking. Then there is a little bit of training required for the court staff. That also we have arranged. We have arranged the program, and many banks offered us assistance. They have their provincial training centers, which they said will be made available for the training of the staff. And I told about digital signature, which we will shortly launch, and we will arrange either on the provincial level, I think I said that, or online, the lawyers will have to obtain the digital signature. That is then, it is then only you can file for the authentication. And also, most importantly, lawyers need to register with this system. And I told about the cost, and one reason why I said the cost, how much you are going to save, how much your clients are going to save. We can't do it free. We have to pay for the cloud. We have to maintain the scanners, computers, and networking, all that. That is all money. So the lawyers will have to pay, and for a registration, maybe for a yearly or 2 yearly basis. But that is far more less than what you spend now. So that is, you are definitely up on the deal. So I suppose I have answered your question.
Thank you, sir. In the commercial high court, of course, we experience a system that our email addresses are given, and the instructing attorneys are informed when the proceedings are ready. Then they have to apply in the normal procedure.
Yeah, I told you that is actually that also needs to be changed. Now that is why this ad hoc digitalization systems. I am aware that there is a system in the commercial high court, and in few other courthouses also there is little bit of things done. They are independent systems. They are not interconnected. So then we asked the question whether you can integrate that. They said no, it is far more easier and better to develop it all. So this is the system. This is the problem. When you do plaster solutions, ultimately it does not sustain in the system. And Dr. Vijay Surya also said about the digital economy and connectivity. And if I may add to that, I showed you about 34 volumes of a brief. In many large briefs, you get procurement guidelines, we may get public administration circulars, gazettes, and things of that nature. For instance, in the Golden Key case, maybe that whole lot of accounts in that company are there. So when the theory advocated by Dr. Hans Vijay Surya is set, you don't need to physically take a printout and attach and make the record big. So you just put the link. So from the link, you can access the procurement guidelines or the gazette or something. And it is easy. That's my answer. Thank you.
Thank you, sir.
Thank you, everyone. I think we had a superb session, and I think everybody would go home after learning something new. So I thank all my panelists, including the Honorable Chief Justice, and all the eminent panelists who are here, because now we have to go for another session very soon. So thank you, and over to you.
Thank you very much, Shehan Souzar, our moderator. Ladies and gentlemen, once again, a very big thank you to our panel today for an amazing session, the 8th session on digital economy and the digital transformation of Sri Lanka. To present tokens of appreciation to our amazing panelists, I cordially invite onto the stage the President of the Bar Association of Sri Lanka, Mr. Rajiv Amarasuriya, the Chairman of the National Law Conference Committee, Mr. Priyantha Alagiyavanna, and Mr. Pandula Vanyarachi, the co-convener of the National Law Conference Committee. Gentlemen, if we could have you on stage to present tokens of appreciation to our panelists this morning. Ladies and gentlemen, of course, a first token of appreciation goes out to our Honorable Chief Justice, His Lordship P. Padman Surisenha. Thank you very much, sir. Also, token of appreciation goes out to Dr. Hans Vijaysurya. Dr. Thusitabe Sekara. Mr. Asela Vaidyalankara. And our guest from India, Senior Advocate Aruneshwar Gupta. And our moderator, Mr. Shehan Soiza. And may I also invite all the members of the panel, along with our moderator, with representatives of the National Law Conference Committee and the President of the Bar Association, to pose for a group photograph. Thank you very much once again to our panel for a very interesting discussion on the digital transformation of Sri Lanka. Thank you very much, ladies and gentlemen. The next session on legal ethics will begin shortly. Thank you very much.
So, ladies and gentlemen, we commence all important sessions on the legal ethics and legal education. So, role of the lawyer in upholding the ethics and professional standard and legal education is the topic of this all important and the final session of National Law Conference. So, I hand over the mic our moderator, Mr. Lasitha Kanwanarachi, to take over and commence the session.
Priyanta? Honorable Justice Arjun Obesekara, Judge of the Supreme Court of Sri Lanka, Mr. Rajiv Amarasuriya, President of the Bar Association of Sri Lanka, Mr. Prashant Lal Dialvis, President's Council, Mr. MUM Ali Sabri, President's Council, Mr. Jagat Vikram Nayaka, President's Council, who are the panelists for the today's session, senior members of the bar, junior members, my dear colleagues. This is the final session of the National Law Conference. When I was walking in for this session, I saw few participants leaving. And one said that they were going to visit the city. So I thought this should have been the very first session of the National Law Conference, not the last session. And now, having said that, now we are almost 45 minutes behind the schedule, so we'll try to catch up and conclude the session. So you all must be awaiting to leave early as possible, tomorrow being a working day. So let us start the proceedings by introducing the eminent panelist. The first panelist is His Lordship Justice Arjun Obesekara. Then we have Mr. Prashant Lal Dialvis, President's Council, who is the current principal of the Law College. We have Mr. Ali Sabri, President's Council, former Minister of Justice. And we have Mr. Jagat Vikram Nayaka, President's Council, to speak to you about legal ethics. Now this session, these four panelists will be giving brief introductions on several key subtopics within the topic, and thereafter we will open the forum for discussion. I think we are trying to give at least half an hour for discussion, because I'm quite sure a lot of people will be having a lot of issues. Now, before starting the session, I have a special request to make to His Lordship Justice Arjun Obesekara. Now, we request the Supreme Court or His Lordship Justice to give us the immunity to speak anything today which will not amounting to contempt of court. Give us the privilege at least today, the parliamentary privilege today, to speak things which will not be charged for contempt of court. Then these people will speak freely. I hope we will get that privilege. And also, now to start the proceedings, now this is a story of, when I was thinking about this first topic where His Lordship is going to address you, it's a story of maybe the story of Beauty and the Beast. The beast is waiting to catch the beauty. Now, is it the case? That story, of course, had a very happy ending. The beast became a prince. are we going to have a happy ending with these present ethics issues? So let me invite His Lordship Justice Arjun Obesekara to address you on the very important and key topic: is the Supreme Court too harsh or severe in dealing with complaints against attorneys at law? May I invite your Lordship?
Thank you, Lasit. First of all, let me assure you that whatever that is said here will not give rise to any contempt issues that you spoke of. We are here for an open discussion. It's very important that you are able to share your views. It's very important that I am also able to share my views. So I can assure you of that. So good afternoon to all of you, the Honorable the members of the head table, and honorable ladies and gentlemen. On the 30th of June, 30th of June this year, I checked my WhatsApp messages yesterday, Mr. Priyanta Alagiyavanna spoke to me and asked me whether I'll be able to come for this conference. At all times, I've tried to oblige an invitation of the BASL, and I said yes. The second thing he told me was it's going to be held in Kandy, and I said that's fine. Then he told me that the theme of the session, he said it will be on professional ethics. I said, well, okay, let me see what can be done. And a few weeks later, I made inquiries as to what the theme was, and I was told that the theme is going to be, is the Supreme Court too severe in dealing with complaints against attorneys at law? So I thought, I've been a judge for 7.5 years, and I thought here I am, asked to come and make a presentation to honorable ladies and gentlemen of the noble profession that we all belong to, and convince you, or to make submissions to you, that the Supreme Court has not been too severe in dealing with complaints against attorneys at law. So roles have changed, and my role today will be to convince you, I would say the jury, to decide, going by the examples that I'm going to give you, whether we have been too strict or not. So my presentation is in two components. I have a prepared text, which I will read out to you, and thereafter there are some slides that I'm going to share with you, which are the actual cases, the facts of the case, and the punishment that has been imposed, because I think that will be important for you to then decide the topic that has been presented to me, that has been asked, where I have been asked to speak to you. So essentially, I'm giving you going to tell you why it is important that we maintain the highest standards of ethics at all times, because we belong to a noble profession. And then I'm going to tell you, well, this is what we have done. Do you think we have been too harsh? So that's the way I have structured this presentation. So we are often told that the legal profession is a noble profession and that it is a privilege to be a lawyer. But have any one of you paused to ask yourself what is meant by noble? So I looked at a few synonyms for noble, and these are some of the synonyms that you see on the screen that I came up with. Honorable, I think we all like to call ourselves honorable, and principled, virtuous, dignified, upright, esteemed, polite, self-sacrificing. So these are some of the phrases I took, and I thought to myself, well, we all like to be called all of these words, because that from the day we entered law school or law college, or law faculty, whatever, the idea has been inculcated in us that we are going to enter a noble profession. So my question to you this afternoon is, does the legal profession really deserve these adjectives? My answer is yes, and let me very quickly explain to you why I say that. So we are in a historical city of Kandy, so probably it's a appropriate that we look at a little bit of history in this regard. Since its beginning in ancient Greece and Rome, the legal profession has had very honorable and non-mercenary traditions attached to it. The service of a lawyer or barrister was given not on a commercial basis in return for a fee, but based on a sense of obligation to give the benefit of their legal knowledge to those who sought it. In return, the obligation of a client to pay a lawyer or barrister was also binding in honor and not in law. As Justice Veeramantri has said in one of his many books, a quaint relic of these traditions is that since barristers did not sell their services for a fee, the barrister's gown had a pocket stitched into its back. Check out a colleague of yours who's a barrister and you will see that there's a special piece behind it, which had this pocket stitched into his back, into which an appreciative client could drop a fee if he wished to show his appreciation. The pocket was on the back of the gown to indicate that the lawyer did not consciously charge a fee and that his services were not given for a monetary consideration. This, in effect, ladies and gentlemen, explains the honorable and honorary nature of a lawyer's calling. So these deeply rooted traditions became ingrained in the professional ethos of English lawyers, and through their influence, shaped the character of the legal profession across the Commonwealth, including Sri Lanka. From the beginning to where we are now, efforts have been made to preserve and uphold the noble character of the legal profession, and such steps have been persisted with utmost devotion. So when you consider the question that has been posed to me, please bear that in mind, that efforts are being made to preserve and uphold the noble character of the legal profession. In a recent speech delivered by Justice Surya Kant, the senior most judge of the Indian Supreme Court who was here for the conference, he said, law should not be mistaken for an ordinary vocation, as at its heart is a calling, and that success in law is not measured by arithmetic gain, but by ethical weight. His speech is available on YouTube. And he went on to say that he went on to describe the true essence of the service of a lawyer by portraying the law to the moral scaffolding upon which our society stands, and he depicted lawyers as the vigilant architects trained to detect the smallest fracture before the structure collapses. Just think to yourself, he said, law is the moral scaffolding upon which our society starts. You all know what scaffolding is. You want to construct a building, we first put up scaffolding to take the weight. So law is seen as the moral scaffolding upon which our society stands, and lawyers, he compared to the vigilant architects who are trained to detect the smallest fracture before the entire structure or before the entire edifice crashes. Therefore, the reputation of these vigilant architects is built not only on the brilliance of argument alone, but on the consistency of character, professional honesty, and moral quality. At the time of your admission to the bar, the requirement is that you be a person of good repute and of competent knowledge and ability. Good repute, competent knowledge and ability. If anyone does not meet this criteria, the Supreme Court can refuse your admission to the bar, even though you may have passed your exams. The Judicature provides for it. So this confirms that enrollment as an attorney at law is a privilege. Remember, it is not a right, it is a privilege that is conferred on a person by the Supreme Court. It is therefore the responsibility of such person to continue to maintain such reputation and conduct at all times in order to enjoy the privilege of being an attorney at law. So the Supreme Court has held, and I think all of us know, at the time of our admission, we have to have good moral standing, competence, and that right through our profession, right through the professional career, we need to maintain that. So what is important is that the practice of the law is not a business open to all who wish to engage in it. It is a personal right or a privilege limited to selected persons of good character. It is in the nature of a franchise by the Supreme Court, conferred only for merit, and therefore may be revoked whenever misconduct renders the person holding the license unfit to be entrusted with the powers and duties of the office of an attorney at law. So it is for this reason that an attorney at law who is found guilty of any deceit, malpractice, crime or offense may be suspended from practice or removed from office by the Supreme Court. Generally speaking, the test to be applied is whether the misconduct is of such a description as shows the attorney at law to be an unfit and unsafe person to enjoy the privileges of an attorney at law and manage the business of others as an attorney at law, or in other words, whether that person is unfit to discharge the duties of his office. So I must perhaps emphasize to you that the decisions we take varies from case to case, because the circumstances, there can be aggravating circumstances and there can be mitigating circumstances. So I found this, I think when we talk about professional ethics, we all look to the book of, we all look to Justice Amarasinghe, and this is what he has said: an attorney at law should advise and represent his client and render professional assistance. So remember, at all times, we are professionals. We must render that assistance conscientiously, with scrupulous care, due diligence, in reasonable time. You must not accept matters that you cannot accept because it's beyond your area of expertise. You cannot engage in slipshod work, evidenced, for example, by mistakes or omissions in statements or documents prepared on behalf of the client. We all know people make mistakes. Everybody makes mistakes, but you have to be very careful. And if your services does not meet the quality of diligent services expected of an attorney. So I just try to explain to you the way the Supreme Court looks at it. We take a holistic view. The profession admits good people, and it's important that good people continue to be in the profession, that if for whatever reason they go off track, then steps have to be taken, because the disciplinary control of attorneys at law are vested with the Supreme Court. Now, having said that, I'll move on to my second segment. So the first segment was addressed to a group of, I use the phrase honorable ladies and gentlemen because I addressed that to the honorable members of the noble profession, to attorneys at law. So the first part of my presentation was to the attorneys at law. Now I want you to take off your hat of an attorney at law and put on the hat of a litigant. Now, and I'm going to explain to you certain cases where, viewed from the viewpoint of a litigant, I want you to see if the decisions that have been taken are good, bad, or ugly. Okay? Right. So, and I promised Lasita that I'll finish in 12 minutes. So 20 minutes. So I have 8 more minutes to take you through the slides. But these are all cases that we have decided in the last 2 to 3 years. So I have 7 cases, but if time does not permit me to go through all 7, I'll probably stop at 20 minutes. So the first case was preparation of 2 forged deeds. There was no search carried out. Instructions had been received to dispense with the search, but the notary's ordinance requires the person to obtain written instructions. So the rule was served, and the issue and the test that was applied by court in deciding what action should be taken is very important, because I have and for that reason I put it on the screen. So the test is this: whether the breach of the rules, and I'm putting this first because I was told, I believe by Lasita or by Mr. Aligivanna, that several attorneys at law who are engaged in notarial practice are concerned, right? Whether a particular breach of theirs or a particular mistake can give rise to a claim against them for professional breach. So the test is whether the breach of the rules or not adhering to the rules or provisions of the notary's ordinance makes the attorney at law liable to be suspended or removed from office. It will depend on the circumstance of the case and whether such breach amounts to deceit or malpractice. And also, I have repeated, depends on the circumstance of each case. So court will go into the facts of each case and decide You remember I spoke to you about deceit and malpractice earlier? Court will see if it's a mistake, whether it is only a mistake or whether it is whether there has been a deceit or otherwise. So what do you think happened in this case? Court came to the conclusion that there was no deceit or malpractice on the part of the attorney at law. Court also came to the conclusion that there was no evidence of dishonesty on the part of the attorney at law, and the rule was discharged on the basis that the conduct of the particular attorney at law was not deceitful. It was only a mistake. Second case, how should you obtain instructions from a client? Again, remember, we are talking about a noble profession where all attorneys at law are professionals. So how should you obtain instructions from a client? This particular case came up. I'll give you the facts of the case. When they were on good terms, 3 friends have taken a loan, or 1 friend took a loan, 2 friends came as guarantors. Later on they fell out. The borrower did not honor the loan. There was action filed, and they retained the same lawyer. That was the official version. But then the case went ex parte against the case was determined because an attorney at law filed proxy on behalf of all 3 defendants, and the case went proceeded to trial, and judgment was entered. Writ was taken out against one of the guarantors, and the fiscal came to seize all her property. She says that's when she got to know about the case, and when she made inquiries, she found that a proxy has been signed by her. And she said, I never signed the proxy. When we went into the matter, the attorney at law pleaded guilty. We found out that the borrower got the attorney at law to present the proxy for all 3, although the 2 guarantors, including this guarantor who complained to us, never went before the instructing attorney. The version of the complainant guarantor was that she doesn't even know this lawyer, and then it transpired that the proxy was signed on the bonnet of his personal motor vehicle outside All Saints Church in Halsdorf. Right? Now the question I have for you is, these are the facts which I've already told you. The question I have for you is that professional conduct? That lawyer admitted, well, I did not check the identity card. Of course, he initially said the borrower brought somebody's identity card. I just accepted it. But later he said there was no identity card that was brought. So I'm going to ask you, what should the punishment be? Is that professional or not? That's why I want you to look at it from a litigant's point of view. Court ordered financial compensation. Court also ordered a suspension of 3 years. This is the second case. Third one, there was the particular attorney at law had fraudulently conspired to attest a deed, made a false statement in attesting the said deed. These are, you buy a property, you are relying 100% on your attorney at law's integrity and honesty, right? You want your deed registered immediately. So there was forgery committed in attesting the said deed. There was breach of the rules, breach of section 31 of the notary's ordinance. And even though the attorney at law claimed he knew the transferor in the attestation, the evidence revealed that the transferor is a fictitious person, found guilty by the High Court in the criminal case. Is he fit to practice as an attorney at law? Is the question I have for you. And the answer is, well, the Supreme Court thought he is not. I have time for one more case. Accepting fees to appear in court in several cases, not appearing in court. Litigants entrust their entire case to an attorney at law, expecting the attorney at law to be present in court to do the job. Paid 4.45 million rupees in this case. When the complainant wanted the documents back, the documents were not returned. He held on to the documents, and this was the decision. Again, money is handed over, and this is a different case. Money is handed over to execute a deed, failed to register the deed, provide a right-of-way that he was not supposed to in the deed. The transferor had died by the time the deed was executed, suspended for 4 years. There's one other case that I would like to, this is the final case. There are two more, but I think this is important because even Mr. Kannunarachi told me this judgment caused a lot of concern among the attorneys at law. So there was this young lawyer who was assigned in a criminal case in the High Court in 2016. In 2021, for the trial, he failed to appear. The case was rescheduled. He appeared on notice. So here you find an attorney at law who has been assigned as counsel, is not turning up in court, and court is now issuing notice on him. Then the defense had to be called. He didn't appear. He was said to be before the High Court. Before the Homagama Court. Next trial date, he failed to appear. He appeared again and defaulted again. And finally, the complaint came from the High Court judge himself, and we had to suspend him for 5 years. I was in that bench. It was not, I can assure you it was not a decision taken lightly. But this is what we were very much concerned with what Justice Amar Singh had said in his book, that once you are retained to appear, you must appear in court. We all know the consequences of not appearing in court, right? So that was the aggravating factor. He was a young attorney at law, and as I said, it was not a decision taken lightly. But the fact of the matter is that he had failed to appear on 3 occasions, and notices had to be sent. So he was a continuous defaulter in court. So that's about the time that I have. So I've crossed the 20-minute mark. And so I had 2 more cases to discuss with you, but I will not do that. I'm also mindful we all want to get back to our respective homes. So the question I have for you is, take off your litigant's hat now, put on your attorneys at law hat, and see what is the verdict of the jury. You remember I gave you this slide. Is the Supreme Court too severe? In the first slide, in the very first slide, I do not know if you noticed it. Sorry, this goes, sorry, in the very first slide, the word the word too severe, I put it in bigger letters because that was the question posed to me. And in the final slide, I put the word too severe in very small letters. So the question you need to consider is whether, going by the 4 or 5 cases I've given you, whether you think the Supreme Court has been too severe in dealing with complaints against attorneys at law. So thank you, ladies and gentlemen, for that very patient hearing. Open to questions.
Thank you, Lordship, for those thought-provoking few words. And I know you all will have many questions. We will give an opportunity for everyone to pose any questions to His Lordship after all these presentations. So now the next presentation, next addressed by Sir Jagat Wickramanayake, President's Counsel. He will address you on corporate lawyers. He wanted to deal with corporate lawyers and notaries rather than practicing lawyers. So he will address you on professional ethics, dilemma faced by corporate lawyers and notaries. Mr. Wickramanayake.
His Lordship, Justice Arjun Obesekara, distinguished members of the panel, Mr. Rajiv Amarasuri, Attorney at Law, President of the Bar Association, President's Counsel, my dear friends, ladies and gentlemen. After listening to what Justice Obesekara had to say, I'm now wondering whether I can say all what I came prepared to tell here. Anyway, I'll just start, before I play my presentation, I'll just quote something from Justice Amar Singh's book. Here referred to a statement made by former Chief Justice Sir Sidney Abrahams about the Sri Lankan bar. This is what he says. The bar of Ceylon has a deservedly high reputation. I have had experience at the bar of many countries, and I am proud to preside in the court where members of the Ceylon bar practice. So that's the reputation. Sir Sidney Abrahams had been the Chief Justice, English barrister, had been the Chief Justice in, or Justice of the Supreme Court in different other countries. But when it came to Ceylon bar, his view about the Ceylon bar was totally different. So the sole reason for this is the reputation the bar maintained at that time, which we ought to maintain even today. So the rules of ethics of the Supreme Court has not been forced on us by the Supreme Court. I could not find it here in this book, but I read somewhere the rules that was adopted in 1988 was prepared based on the rules that the Bar Association has had previously, prior to that, among the members of the bar. So we have prepared the rules for ourselves to govern ourselves. So the same rules or something based on those rules have been prepared by the Supreme Court in terms of the Article 136 of the Constitution. So when it comes to professional ethics is a group of standards relating to the activities of professionals. So this is nothing much. So the Supreme Court conduct of an etiquette for attorneys at law, the rules, published on the 7th of December 1998, I think it's 1988, made by the Supreme Court in terms of this article. So the rules, I have only quoted three or four rules here to show how these rules will apply to the lawyers in employment as well. So the Rule 2 says, shall apply to every attorney at law. So once you become an attorney at law of the Supreme Court, the rules will apply. The Rule 3 says, an attorney at law who holds any office appointment in his or her professional capacity shall be entitled to practice the profession only insofar as is necessary for due performance of its duties in such employment. So this is about the employment. The Rule 60 says, attorney at law must not conduct himself in any manner which would be reasonably regarded as disgraceful or dishonorable by attorney at law of good repute. And the final rule that I would like to draw your attention to is Rule 61, where it says the attorney at law shall not conduct himself in any manner unworthy of an attorney at law. So this is the standards set by the Supreme Court for the attorneys at law. So the main areas, which is based on the rules, the main areas that cover, first of that is the conflict of interest. If you have a conflict of interest, how the rules will apply. Then the confidentiality, because you work for one company today, probably you will join a competitor tomorrow. So you have discharged your duties as an attorney at law, maybe in the capacity of a manager or a legal officer or whatever it is. So how these confidentiality rules will apply to you. Then the professional misconduct, you might have to resist the pressure that comes from your employer to do certain things. Then the impartiality and the neutrality. So you have, especially the notaries must serve all parties equally in discharging the duties. I will come to that. Then the ethical and legal compliance adhering to statutory standards is mandatory for maintaining professional licensing. So these are the areas that we need to be careful when once you become an attorney at law in employment. So the corporate lawyers, mostly the issue that they are faced with as I know, first thing is the pressure that they get from their employees to do certain acts. Because you probably will have an issue in discharging your duties. The pressure comes from the top, from your management, from your employer to do certain acts. But if you carry on, if you do or you execute such an act, probably it will conflict with the rules of ethics that you're bound by. So, the Justice Amar Singh very clearly says, if there is a conflict, or if there is any pressure coming from your employer to do certain acts, which you believe would conflict with the rules of ethics, you are supposed to you're not supposed to do that act. So you will have to protect the rule that you're bound by as an attorney at law. Because the reason is you're in employment by virtue of your license as a lawyer. So if you lose your license, you will eventually lose your employment as well. So the same principle applies once you become a notary. In fact, the first authority or the first case Justice Obesekar cited, 8 of 22, was one of my cases. I only defended that law in the Supreme Court. It was a very difficult case though. Although finally the rule was discharged, Mr. Amar Suri wasn't there at that time, because the Bar Association was basically making submissions to say that the particular lawyer had done something wrong. So there was no support came from the Bar Association at that time. So, but in fact, she had not done anything. She had not done that. The Supreme Court saw it very well, and the evidence was led, and finally, she was discharged from that. But here, you need to be careful about something, because now when it comes to your employment, I know the pressure that comes from your employer, you probably will have to carry out certain duties. But you should be able to put your foot down and say, this particular thing I cannot do. Not because of anything else, purely because of the Supreme Court rules. If the Supreme Court rules say that you're not, if anything that covers in the Supreme Court rules, you're bound by that, and you will have to follow that. Even at the cost of your employment, you will have to follow it. So employers may issue directives that contradict ethical or legal obligations. You have to be careful about it. So obedience could lead to professional misconduct, while refusal could be seen as insubordination. Doesn't matter. You can defend yourself in case if there is a termination. The lawyers have an implied duty to support their employer's interest, but not at the cost of breaching ethical standards. So ethical standards would be of paramount importance. The Supreme Court and Code of Ethics place ethical integrity above employment loyalty all the time. That is what Justice Amar Singh had very clearly said. So look at this statement by him. A practicing member of a profession might additionally engage himself in an occupation, trade, business, or enterprise. However, in such a case, an attorney must not directly or indirectly engage himself in other work that may be dishonorable or derogate or detract from his status as a lawyer or affect the reputation of the legal profession. So, so this is the dilemma that the organizers wanted me to talk about. Now, I have referred to this before. So the main issues faced by the lawyers in employment mostly connected to the notarial practice. Mostly in connection with the notarial practice. So what you need to understand, especially in this particular matter, the Bar Association made extensive submissions to show that the notarial work that is being carried out by a lawyer, in that context, it's not like any other notary doing. When an attorney at law who has got license as a notary by virtue of his office as a lawyer will have to be, will have to do all notarial work without violating any other rules. So if there is any misconduct as a notary, will definitely treat it as a dishonorable practice as an attorney at law. Now the issue is, if you look at the recent amendments in relation to execution of deeds, I think we need to talk about it. Now rules 31, 9 and 10, where it says those rules were there for a purpose. Rule 9 says, Rule 31.9 says, either you need to know the transferor or you need to know the two witnesses who would in turn know the transferor. But now the amendment that was brought in recently to the notary's ordinance, Rule 31.10 very clearly says, if you do not know the notary and the two witnesses, you are not supposed to execute the deed. Now we have repealed that. I really do not know as to why we have repealed it. The Parliament has repealed Rule 31.10. So does it mean that you can now execute a deed where you would not know the transferor and also you will not know the two witnesses? Now they have amended Rule 31.9 to say by being satisfied in relation to the identification by examining the national identity card or the passport, you can now execute the deeds. So this will lead to many problems, especially in the corporate sector. Because I have come across many cases like that in the district court. What happens is, especially when there is a fraudulent, the forged deed is prepared, a fraudulent document has been prepared, what they do is they will try to obtain a loan. So for that particular purpose, I don't know whether you all have read it. Recently I saw the National Savings Bank. Definitely the lawyers were not accused for anything in that, but of course, a particular officer had prepared forged documents and obtained millions and millions of rupees loans from the bank itself. So the lowest point, some officer had prepared it. He has put all the documents to the next officer like that. So now all these people have been arrested by the CID saying that they're responsible. So the next step would be the lawyer. It will come to the lawyer as well. Because the lawyer, unless you know, this actually happens with this way. Now, if the lawyer has been called only to do the mortgage bond, it's about mortgage. But further, I know some of the banks have permitted lawyers to execute the transfer deeds as well. Now, these transfer deeds being executed by the lawyer will definitely not know the transferor. It's not like a practitioner, because they probably will have some kind of a connection with the client. But when it comes to the bank employees, they do not have any connection with those people who come to take loans. So using the fraudulent documents, the forged documents, they will come to the bank and they probably will obtain the loan, and also they will get the lawyer to execute the transfer deeds as well. So finally, when the real owner, the true owner, challenges the document in the district court is different, but by way of a criminal case, either by complaining to the CID or to the police, the lawyers also will fall into trouble. So then the issue would be whether you have complied with the rules of notaries as depicted in the notary's ordinance. So the earlier, I think, the manner in which it has now been amended, you probably will have a defense in that, But still, if you go into the question, as to how you were satisfied, only by looking at, because we know, day in, day out in papers I have seen, there are kacheris being carried out by individuals. The national identity cards being prepared, the passports are being prepared. So only by looking at a national identity card that is produced by a fictitious person or somebody who just walks into the bank, whether you can be satisfied yourself. So this is something that you need to think before you execute, especially the transfer deeds, because that's not really not within your employment duties, it's outside that. But sometimes, even within the employment, the corporates might ask you to do. Right, then so basically, this is what I wanted to talk with you all or discuss with you today. And I'll be ready to answer any questions in relation to these things. So be very careful, be very mindful when you're executing deeds, because the deeds is the problem that the notaries in employment or the lawyers in employment mostly face problems with. Thank you.
Thank you, Mr. Vikramanayaka, for those important words. I'm sure you will have many questions in the Q&A session. Now moving into the next topic. It's a very controversial area and of course very unclear area. Upholding legal ethics in an increasingly digital space. So to speak few words on this particular topic, may I invite President's Counsel Mr. Ali Sabri, who was the former Minister of Justice as well.
Your Lordship, the Chief Justice, Your Lordship Justice Arjun Obesekara and my respectful colleagues from the bar at the head table, President Bar Association, and dear friends and the colleagues. I think after two very illuminating presentations from both Justice Obesekara and also my friend, Mr. Vikramanayaka, I think I will confine very specifically to the area which I have been entrusted to, upholding legal ethics in an increasingly digital space. It's a very interesting topic. I think there is this saying, very familiar in the Western world, particularly in the business, that is, either you innovate or perish. I don't think that's only true to the business. It's true to everything else, including our profession. So with the times and things move, we need to keep up with the pace. Otherwise, either you have to hang your boots out, or you will face the problems what we were discussing. So why it is important that we win the confidence of the people? May I only quote this quotation from the American Bar Association, ABA Canon of Professional Ethics, published by the American Bar Association. It has said, the stability of the courts and all departments of government rest upon the approval of the people. It is peculiarly essential that system for establishing and dispensing justice be developed to a high point of efficiency and so maintain that the public shall have absolute confidence in the integrity and impartiality of its administration. The future of the Republic, to a great extent, depends upon our maintenance of justice, pure and unsullied. It cannot be maintained unless the conduct and the motives of the members of a profession are such as to merit the approval of all just men. So you will never be able to win everybody. but that we are trained to think of that reasonable man in law. So if you can justify and win their confidence, then you are won. Otherwise, like any other profession or any other area, we shouldn't say that we are not going to be there. No. So from politics to the everywhere else, the day which we lose the confidence of the public, and that's the end of it. Probably our profession also. Therefore, it's important, all of us, has a duty to do that. It's important, lost delays is a huge issue. We can't consider this is our privilege and this profession is for us. No, this is for public. This is the way in which we can contribute, and then of course if you do it properly, among other things, you can also make good money. But that should not be the motive. If we think that when you hear cases quickly and cases are over, then there shouldn't be the legal profession exist in advanced jurisdiction like US and UK. The other way around. People will have more confidence on the system and more people will start coming and deliberating on that. So what happens is upholding legal ethics in an increasingly digital page. One important thing is, doesn't matter which platform, doesn't matter where it is, principle remains the same. So ethics remains the same, platform changes. That doesn't mean that our responsibility changes. It's like a defamation. At the beginning, people thought defamation. Defamation started with people blasting each other. Thereafter on papers, thereafter on radio, thereafter on television, thereafter online. Principles are the same, whether a particular speech or expression create that defamation. So here also the same principles are the same. Ethical standard, what is expected from an attorney at law, is maintained across the board. Doesn't matter wherever it is. So therefore, if you have that principle in mind, then it doesn't matter which space you are doing it, you have that responsibility. So I'm not going to take much of your time because of the limited time I have. I'll just directly go into my presentation, and if anyone wants, I can email the detailed paper which I have prepared it through Lasita. Legal professions stand at the crossroads of tradition and technology. Our work now operates within digital platforms, data systems, and AI tools. The medium has changed. The mission has not. Duties remain primarily to the court, be justice and candor. To clients, confidence, loyalty, and competence. If you are not competent enough, as Justice Obesekara very correctly pointed out, you shouldn't accept it. Then, to the public, dignity and integrity. As Justice Obesekara read this, the famous judgment of Justice Mukherjee, the practice of law is not a business open to all who wish to engage in it. It's a personal right or privilege limited to selected persons of good character with special qualification, duty ascertained and certified. It is in the nature of a franchise from the state conferred only for merit and may be revoked whenever conduct renders and persons holding the license unfit to be entrusted with the powers and duties of his office. That makes it very clear. You can't, as a matter of right, I have passed the finals, I need to continue to be in this profession. That's not the case. Like politicians, you can become, the day you are not delivering, people will chase you out. And then you have to find something else. Luckily for us, we have this profession. From Greek ethos, meaning character, what is ethics? Simple. From Greek ethos, meaning character, moral values and norms. That's what ethics are. Ethics guide behavior within a group or a society. Professional ethics mean standards of right and honorable conduct. For lawyers, honesty, confidentiality, integrity, and respect to code. The need for professional ethics that I read earlier, why it is the American Bar Association put very high standards so that they get in there. Of course, they are going through a big crisis with the current president. That's a different matter, but lawyers will fight back. Now, professional ethics in Sri Lanka evolved from colonial era standards. Initially, we had the codified ethical rules, legal framework, I'm not going to discuss, Judicature Act, Supreme Court rules. Then Jagat discussed the other key rules. Then, most important thing, practice is shifting from place-based to platform-based. Lawyers now draft using AI tools. When you have availability, you should rule it. Otherwise, what they are saying is very simple. AI will not replace the lawyers, but it will replace lawyers who use the AI with lawyers who do not use the AI. That's the difference. Research in digital libraries appear via virtual hearing. Ethical competence now includes technological competence. If you are not technologically competent, probably like anything else, going forward, probably you are not good enough to represent your client because so much it is integrated with the system. That is why American Bar Association Rule 1.1 and Comment 8 keep abreast of technical changes. It has made it mandatory for you to have and obtain technical competence. That's how other countries are moving fast. Technology must serve justice, not convenience. Technology must assist you. But buck stop with you. You can't say that AI made this mistake. I'll come to that. You know? So you use it, but responsibility remains with you. Then, technological era, oral norms, apprenticeship at the beginning, gentleman's conduct. Codified era, 1988 rules, conduct and global equivalence. Digital era, AI tools, online marketing, cross-border clients. That's what's happening today. Future, AI governance, digital accountability, and cyber ethics. The lawyer's role in a digital age, very important, confidentiality. Imagine you use somebody else's this thing, you are in many of the WhatsApp group, share that in a different WhatsApp group and give that confidential information. What happens? You're in trouble, they can sue you. So therefore, confidential use, encryption, two-factor authentication, and vendor contract. You have to see that. Sometimes you can go and agree on something, you don't read any of those things, you just go and say, yes, I agree. They must have access to confidential information in your one of those encrypted messages. What happens? Don't take it lightly. I mean, probably Sri Lanka is not that dangerous, but if you look at very carefully, now how the Mossad went after the entirety of the Hezbollah's leadership in Beirut, it depends on a pager. They send the pagers, they knew that they were making a contract, they breached that contract, that information, those pages were made in Netherlands, they got to know it was done, they infiltrated the Netherlands, that company, they put all the information in, and when the pages went, it got blasted. Imagine the cost. Because Israel, you got away with it. Imagine anyone else. That's the danger. And then AI verification. Verify sources, disclose AI use, trust but verify. One thing for sure, AI is also over a period of time had to get used to it. For a Sri Lankan law, it gives all false references. Don't rely on that. Ever rely on it. But it helps you to identify the concept. It breaks down the concept. Use that and do your own research. At least for the time being, until, like anyone else, AI gets used to it. But in advanced jurisdiction, like in UK and US, it's much better. You know that up to date. Then conflict checks. Adapt for multi-jurisdictional digital platforms. You need to look at in different areas. Because the rules in our area are not similar to other things. So somebody was telling me the other day, I saw some Sri Lankan lawyers in Australia advertising. I said, that's in Australia. Sri Lanka, you can't until it is the law. Yes, Sanath is here, he will tell that. So therefore, it's important that you understand cross-border jurisdictions. Then don't carried away with that. Social media, very important. Maintain dignity, avoid promotional and prejudicial content. Important. But in the meantime, don't be scared of the peer pressure they try to put you in. And the lawyers are in, judges have been, there is organized pressure try to put you in. When a case is being heard by the judges, and when you appear for a client during a very difficult time. One thing of that you do not use it to promote yourself, but something else, you succumb to the pressure. You shouldn't. So that you have to have that confidence within you. Then virtual hearing. And the virtual hearing goes, you have to respect the dress code, background and confidentiality. You can't be from your bedroom or from the kitchen logging in. You need to do that. And it happened in India and other places and all those things. You can't do that. So you are in court, whether virtually or otherwise. That's what he's saying, that platform can change. Your responsibility to court does not. In the meantime, merely because of the mistake, you can't shut it down. I remember in the Commercial High Court about 3 years ago, we introduced, there was one mistake, one person spoke and somebody came in. Merely because that happened, the entire system was shut down. You can't do that. So if that is the case, you call him and tell him, don't do this, and give a little bit of responsibility. Because excuses are not going to take our profession to the next level. We need to take that responsibility and people will adapt. I'm not saying that just because Justice, His Lordship is here. Now, Supreme Court, everybody thought 5 judges, 5 benches are coming in. People will not get used to it. Just 2 months down the line, people are adapting. And cases are being heard. That's very important. Otherwise, the whole system will collapse. Role of the Bar Association. I think President is here. I think you must introduce a digital ethics addendum to the 1988 rules. It has to come quick. Already published, comparable regulation, already published in thematic guidance. SRA, that is the Solicitor Regulatory Authority, have an AI risk outlook in 2023. Sri Lanka must follow that. Mandate continuing professional development on AI, Personal Data Protection Act, and cyber ethics. No point finding only fault with them. They must be educated, guide them, give them an opportunity. Then, if they don't still comply, then go after them. Because sometimes they don't understand this. You can't find fault with it. So therefore, it's important that they should be given a little bit of time, train them, particularly the youngsters and the newcomers to the profession. If they have come with so much of expectation. Establish verification protocol on AI-assisted work. Create confidential reporting for digital misconduct. So all these things are necessary. So there is a lot to do. Then regulating the digital age. How do you do that? Regulation must be firm, must enabling. You can. I remember when I was the finance minister, I told our tax collectors, make a karan none hariyata mona vidiyatada. අර බඹරු මලෙන් රොන් නුරා බොනවා වගේ. ඇයි ඒ? මල තලන්න නැතුව රොන් ටික බොන්න ඕන. ඒ මිනිසුන්ගේ ඔක්කොම ටැක්ස් ටික අරගත්තම ඒ මිනිහාගේ බිස්නස් එක බංකොලොත් වුණාම ඊළඟ අවුරුද්දේ සතපහක්වත් නෑ. You have to have that balance. It's important that we must understand that you can't over-regulating it and kill the innovation. That's the worst thing you can do. We will be going backward about 25 years. So therefore, it's important, while regulation must be firm, but must be enabling. Promote innovation. Promote technology. The Bar Association must take the lead on that. Focus on guidance before punishment. Don't punish them before even they know what it is. So guide them, train them. That's why, I don't know, we have probably different opinion, but I say it's time that we must introduce this CPD. CPD is a must, otherwise we'll perish. But it should not be mandatory at the beginning. The only way to comply in Sri Lanka is that if His Lordship Chief Justice said that, please cooperate with us and hear cases till 6 o'clock. We'll try to help. No one would have cooperated. No? Because he put his foot right and said that 5 benches are here from the morning to evening, people are falling in line. That's how it works in this country. So therefore, it's important that CPD must come. It can be voluntarily at the beginning. It will be licensing at the beginning. It will be attractive to the people of the Bar Association at the beginning, saying that competency certificate. For example, I've studied this so much when I was the president of the chairman of the Future of the Legal Education Committee. Both Lasita and Prashant Lal was part of that committee at that time, and Justice Kodagoda also. The important thinking of our future, we must continue to enable them to acquire those things that are required. Give them competency certificate. Then foreigners or whoever have the right to check whether this person whom I am going to retain is competent to appear in this kind of cases, civil cases and all those things. But that will not have problem of continuing to appear. They can continue to appear, but that will probably encourage more people to come voluntarily and agree on this. So I suggest that. Encourage innovation while preserving integrity. Key idea is ethics should guide technology, not chase it. Global case studies, we all know that. United States, the case versus Mata versus Avianca Incorporation. AI, early time, 2022, they used AI, ChatGPT, and put a case. Wrong reference. The Supreme Court said this wrong reference, sanctioned it, but they did not disenroll them or suspend them from profession because early time. But it was a stark warning. Massive publicity was given. American Bar Association took it upon itself to educate their people, and now very hardly that mistakes are happening. UK High Court warning on fake citations. That happened in UK also. Singapore, mandatory AI and cyber security guides. India, Bar Council warn against online self-promotion. So I think it's time for Bar Association to create a new committee, look into this and introduce that over a period of time. And thereafter, probably Supreme Court can take over after giving a little bit of time for them to get used to it, your lordships. Adopt tech computers as a part of ethics, update disciplinary framework for online conduct, build confidence in justice through responsible innovation. Our goal is not to be digital lawyers, but ethical lawyers in a digital world. That's what we should do. So technology must be amplify virtues, not erode them. 3 takeaways before I forget it. Ethics travel with us, whether it's online or offline. Doesn't matter. Skill today includes technology. Just like your writing skill 100 years ago, today, and typing skill 40 years ago, computer skill 20 years ago, AI skill today, digital skill today is going to be a must. Next one, the bar must lead with guidance, education, and integrity. Probably, I think Law College also can probably introduce on some technological classes or something for the final year students, or at least the apprentices. I will just quote with this quote, a beautiful quote of Oprah Winfrey. She says, real integrity is doing the right thing, knowing nobody is watching. You are not doing it because somebody is watching. You are doing it because that's the right thing to do. Thank you very much for the patience here.
Thank you, sir. Now, the last part of these presentations, we are revisiting the fundamentals, beginning. The legal education for development of professional ethics. I think we have the best person to speak on this topic. The principal of the law college, and not only that, he's the person, he's the lecturer who's teaching legal ethics at the law college. May I invite Mr. Prashant Laldi, Alvis President's Council.
Your Lordship, the Chief Justice, Honorable Justice Obesekara, President of the Bar Association, distinguished fellow panelists, and ladies and gentlemen. My area entrusted to me is about educating on ethics, and I like to share my experience in 1 year as the principal of Sri Lanka Law College, where it is mandatory that the principal must teach ethics, and you are not paid for that, Lordship. That's a part and parcel of the principle of Sri Lanka Law College. And as a disciplinary committee, as I am the chairman of the 7th disciplinary committee appointed by your Lordship, and I see people coming before us on these disciplinary issues. So I like to share those experiences with you. Ladies and gentlemen, coming before you, I went to the saloon because I want to make myself a little younger with a tint and things. And there was a very interesting program on the radio. They were asking questions, who is more useful, lawyer or a policeman? And what do you think the answers were? At that time, with this controversy, the policeman. At least one Lekha, the way she spoke, probably is a lawyer, she said lawyer. Halfway through the program, they interestingly changed the question. They put the question, whom will you get married to? Policeman or a lawyer? So most of them said not both, and majority of them said lawyer. None said they want to get married to a police officer. So this is the dilemma that we have as a profession, as lawyers, how we are projecting to our society. The task with us, your Lordship, as chairman of the Incorporated Council of Legal Education, is to mold the future of these young lawyers. Who are the lawyers who are in the future? This is it. Generation Z. What are they? What are they doing in the world? They are changing the politics. Madagascar, they are fighting. We have to analyze the profile of the future of this Generation C if we want to teach them ethics. Ladies and gentlemen, they are fighting for, interestingly, the values that ethics speaks about. The latest Morocco, it was about health and the facilities they have. Nepal, it was stopping of a social media, and which finally led about corruption. This is what Generation Z is, isn't it? Right. So is it difficult for us to teach them ethics? I say no. I say no. They are very much alert to ethics. It is about how we teach them, how we approach them. That is the critical factor. Ladies and gentlemen, we have a very interesting scenario when it comes to ethics. We have Sri Lanka Law College. That is the institution that brings out attorneys at laws. But don't forget, there is, around the country, there are universities, institutions that brings in to law college who only sits the exam and come for a practical training and go home with no background or no teaching of ethics. This is the dilemma that Sri Lanka has. Even Sri Lanka Law College, your Lordship, put the line on last 19, admitting 210 students to Sri Lanka Law College. It's customary that Lordship decides the exact number that Sri Lanka Law College should admit. I like to share the demography of the first 5 set of students. The first student come from Kambussawala, Beliatta, my lords. Second one, Nittabuwa. Third one, Watugedara, Balapitiya. Fourth, there are 4, Hatton, Moratuwa, Rajagiriya, Pitakote. And 5th, Avissabella. Now, those are the students who will enter Sri Lanka Law College next January. You see the 8 people that come from. They are from different demography, different backgrounds. These are the people who will come to Sri Lanka Law College to our purview. Immediately, with Sri Lanka Law College, we have a girl who is an economist and a statistician we entrusted her to do a survey. Age-wise, economy-wise, do a survey and tell us exactly what they are. Because we have to cater to them. Because under your lordship, we made English mandatory. Unfortunately, we couldn't make them Parliament with threw it out that they should sit for the exams in English. But we teach English at Law College. Your lordship was very particular that we make it mandatory. And the council unanimously agreed. Because that's a gap that it has. The language, English. And through English, my deputy principal is handling that subject, Mr. Shahan Pereira. He's teaching the values, ethics, the Latin terms. Say, res ipsa loquita, what does it mean? That is so unique to we lawyers. We make them proud of being lawyers in that class, my lords. Your lordship was very appreciative of our effort. So we are molding them from the day one at Sri Lanka Law College. But sadly, that doesn't happen in other institutions. So this is the dilemma, Mr. Amarasuriya, that you have to look at it. You and I know, law faculty, there are, in one batch I teach criminal law there, I taught criminal law there, and out of 303, 167 are girls. Have we done a survey, like what we are now doing at Law College, what has happened to them? Where are they? What are they doing in life? It is very important, Mr. Amarasuriya, the president of the Bar Association, we must make a survey about our young generation who have taken notes recently. Where are they? What are they doing? And how we should approach this scenario. Next, I come to a very interesting point, whether hard, severe action is good or bad. That is exactly what your lordship tried to point out. Is the Supreme Court more severe? Your lordship put in big letters, and finally you ended up with small letters. That was a beautiful, touching approach. Let me share our experience. Ladies and gentlemen, Sri Lanka Law College exams, students copy. And they get caught. And even a member of the parliament got caught. A doctor, medical doctor, mind you. He was given only 3 years. The Council of Legal Education decided, and that didn't stop us. For the last 2 exams, 20 copied and found, 22 copied and found. And what the council decided was, we have to be hard now. We have to be severe. They deprived them, and we deprived them of permanent student, losing that permanent studentship. My dear friends, I'd like to share one example. This is how they copy. Effort they put into copy. They type it in so small things with a thick glass they wear. Can you believe? And 22 students copied like this kind of methods. One girl even on the calf. We had to get a lady invigilator to check on that. Do we want lawyers like that instinct? That's what the council decided. What do you think? Are we severe when we say we should deprive of them severely? No. Our council decided we need 2 character certificates to become a lawyer. Here we are. Can we allow them to be lawyers when we are aware that they have done this? So I believe, my ladies and gentlemen, severe punishment is required. Even for attorneys at law, they have breached it. We leave in your lordship's hand to be severe. So otherwise, people don't get it right. We have a rule called attendance, and I, as the principal, enforced it 100%. A lot of people are upset, but my council, led by Honorable Chief Justice, stood by with me. My students started avoiding me like a leper. because most of the people could not sit. That went on. I kept on working on very strict system. And my dear friends, this is the point I want to drive. Young people follow, they are very impulsive. So they were angry with me. That's how the young people are, whom I handle. They are very impulsive. You have kids of that age, and I'm sure you understand them. That's how it is. They are. Even with a father, they would argue. We would never argue with our father at our young age. That's the generation that I work with. So they were avoiding me like a leper. And the results came, and the principal's son failed the exam. That's my son. That's the place where they realized that this man is trying to maintain rules. Because I would have had access to papers easily. So my son failed. So in our life, we have to be consistent. We seniors have to lead it. Ladies and gentlemen, in this hall, we have seniors. Very soon we will have a junior bar conference, isn't it, in November? We have a separate one. Here we have you and I are seniors. We should set an example. We should be strong. We should be strong about it. Because whenever, my lords, when I go for the Anandanal, the big match, they would shake hand with me and said, Machang, can I have an AC room to pass the exams? That's how they look at law college. They think I am principal of such an institution. We, the Incorporated Council of Legal Education, during this period had made it very strong to show, no, it is not. We should walk the talk and show that we go by the rules. And that's how we should operate. We, the seniors, has a major role to play. They look upon us. There may be short time periods where they may be angry with us, but we must keep going. So that's the message I like to share, ladies and gentlemen. Just the last point. We belong to the most proud profession in this scenario. We, Sri Lanka Law College, from the day one, we tell them that you are a lion. That's a symbol we give them. You are a warrior, you are a gladiator. We started from year one, that scenario. And you won't believe, the attendance of the first years were very high, my lord, your lordship. So that's how it is. And this generation, my lord, your lordship introduced digitalization of the attorneys at law from this year. First day it was, they were at law college, it was tough, but they ate up fast. We completed it, my lords, during the correct period. And your lordship, the Supreme Court requested us during this whole digital period, the first 2 months, for us to send volunteers. They were adapting, they were very fast, and they helped you to achieve that target, my lords. This is the generation. This is the young generation. They are beautiful. They are amazing. Provided we give them leadership, guidance. So we tell them that you are a lion. Jagat, I went to a dance, Colombo Trinity College dance. You were there, I think. There was this big lion, my lords. At the end of the dance, I carried it and I kept it in my chambers, my principal's office. And I tell students that you should be someone like a lion. Show this lion, which I got from this Trinity dance. And I tell them a lot, the lion always will not, if you throw a stone at a dog, he would bite the stone. But a lion will look at where it came and attack there. You should be like that, a lion. How to be a lion? This is my ethics class. I tell them you have to be prepared in your case. You must follow instructions, be strong, so that you face any senior even in court like a lion. That should be you. We should tell them stories, my lords. Stories to make them powerful. One day I was teaching them yes but theory. How you should handle court. Respect court. You should never say, no, my lords, no, your honor. You must always say, yes, my lord, but my lord. Now, who taught us? Colvin Nardi Silva. Now, I said, Colvin Nardi Silva said that, yes, but I go a little beyond. And I tell them this is very useful to handle your parents, your girlfriends, boyfriends. Say yes, go little and say but. You can win them over. It's not only in court, it's a part of your life, culture. Yes, but. But very sadly, in the class, only one boy knew who Colvin Nardi Silva is. Now this is what we have to understand. What we are now trying to do, my lords, is we are trying to make small movie clips. We are waiting till the exam is over. Please help us by association with this. We can collaborate. Please support us, any one of you, to sponsor this, because our students will do this. We have a unit 244. Our law college number is 244, even by the municipal council, Manisha. And there, the students will themselves create this video. Not outside production. We will train them. We have a lot of young people in the media. They will train our students. And we will make 15 minutes clips of Mr. Colvin Nardi Silva. Mr. Ali Sabri, we are even thinking of you. At the moment, title is Single a Debater to a Minister. The path. We must inspire with these stories. That is your story, right? Single a debater to a foreign minister. We must inspire with these stories to the young people. We must make them proud to be a lawyer. Then ethics will automatically come. They will be ethical. When they are proud to be a lawyer, they will be automatically ethical. Now, ladies and gentlemen, this is me. When I came from the university, this was when I was in the university, I wanted to be like Che Guevara with a cigarette. So I had long hair. I was an ardent follower of Che Guevara. So this is me. Now what happened was, I want to come for law college. My father is a law college product. Now he told me, son, I have tolerated you so far with this, which I didn't like, but you are going to my institution, which is law college. This is the place where professionals are made. You have to cut your hair and go. That's the rule. Because I was the law students union secretary. So don't insult me, my son, please. So I cut my hair and went to law college. That's the day I realized the difference of a university and law college. So I show this to my students and tell them the story. The difference between university, a scholar, and a lawyer. Big difference. So this is how we should approach young people. And your lordship has given me permission, as indicated, your lordship initiated, that we should have advocacy programs, civil advocacy and the criminal advocacy, and we are going to launch in January and we are at the moment making the syllabus and with the approval of that. But your lordship went further. Lordship wanted other professionals to come to law college. Other professionals. So we are going to make program for law for marketeers, law for finance and accountants. Now, what is the center for all professionals? Law. Every profession needs law. We must make sure our students understand that law is the center. Law is the focus of life of any profession. So when we launch that, all professionals will come to law college in the name of law, as a center of law, We will have get-togethers, networking, and all that. And we will make law proud. So, ladies and gentlemen, I have great belief in the next generation. It's the approach that matters. And Bar Association already signed with us to make internships program. MOU, the council, as well as the Bar Association Council has both approved. So please help us with finding interns from our law college. That's my humble request to all of you. Please help us. With that, I'm with confidence that the future of law, ethical lawyer is very in safe hands. It's very promising. I conclude my session. Thank you.
Sir. Mr. Alagiyavanna is looking at the watch, I think. But we were given 1.5 hours, and 1.5 hours expires at 1:45. So we have about 6-7 minutes for a Q&A session. If anyone has questions from this eminent panel, you are free to ask. We have only 5 minutes, so quickly put your questions out. Can we have some people with mics there? Any questions on Justice Obesekara? He spoke to you about this Supreme Court. How is the Supreme Court looking at the whole thing? It seems all are eagerly waiting to go for lunch, it seems. No questions. Since there are no questions coming from the House, I will put one question and conclude to Justice Obesekara. Now, Your Lordship mentioned about rule matters. Now, and also Your Lordship, when we were discussing in the morning, Your Lordship was telling me about how that, in that particular case, how that particular lawyer did not appear despite of notices. And one of the defenses given that he did not receive notices because he has changed the address. How do we, as practitioners, how do we avoid that? That is a common mistake most of us are making.
If I can just put that question in context, I did tell you that this particular attorney at law appeared. Let me tell you first before the rule, and then tell you what happened after the rule. The particular attorney at law didn't appear in, having taken the assignment, did not appear in court. Notices are served. He appears in court, which means the notice has been served on that particular address. He then takes a date, doesn't appear. It happened on 3 occasions. Then there's a complaint from the High Court judge, and then the Supreme Court takes action. The Supreme Court issues notice on that particular attorney at law. He disregards, and that's the part I didn't tell you. He disregarded notices sent by the Supreme Court registry on 2 or 3 occasions. The excuse given for that, what happened after the rule was served, was that I have changed my address. The address I gave to the Supreme Court at the time of my admission as an attorney at law has now changed. On whom is the responsibility to change that address? I think the responsibility is on the attorney at law. In fact, now with the digitalization drive of His Lordship, the Chief Justice, a register of all attorneys at law the registry is being updated, and all attorneys at law have been asked to update their data. And if you change your data, for example, you change your address, it is your duty to inform the body that gave you the license to practice. That's my view.
Thank you, Lordship. Any other questions? Otherwise, I will hand over to the Honorable, to the Chairman of the session. Since there are no questions, may I invite Ms. Alagiyavanna or the... yes, please. Thank you very much for the patient hearing, and I thank the eminent panel also for the wonderful presentations they have made. Thank you very much.
Ladies and gentlemen, I now cordially invite onto the stage the Chairman of the National Law Conference Committee, Mr. Priyantha Alagiyavanna, and committee members Ranjika Jayawardena and Manori Pathirana to hand over tokens of appreciation to the esteemed panelists today. Our first token of appreciation, ladies and gentlemen, is awarded to Honorable Justice Arjun Obesekar. Thank you very much, sir, for taking time off your busy schedule and imparting your knowledge on everybody present here today. Also, Mr. Prashantalal Dialvis, President's Counsel, Principal of Law College. Thank you very much, sir. Also, President's Counsel Ali Sabri. Thank you very much, sir, for imparting your knowledge on all our attendees present here today. Also, President's Counsel Jagat Vikramanayaka. Thank you very much, sir, for your presence here today. And of course, to our very able moderator, Mr. Lasitha Kanuvanarachi. Thank you very much, sir. And may I invite the representatives of the National Law Conference Committee to pose for a group photograph with our panel. Thank you very much once again, sirs. Ladies and gentlemen, could we have a round of applause for our panel? I now take this opportunity to cordially invite onto the stage to deliver the vote of thanks Charana Kanakagamage, the co-convener of the National Law Conference Committee.
Thank you, Shalan. I promise I won't take long. Your Lordship, Honorable Chief Justice of Sri Lanka, Preeti Padma Sursen, our chief guest, Honorable Justices of the Supreme Court and the Court of Appeal, Mr. Rajiv Amar Surya, Attorney at Law, President of the Bar Association of Sri Lanka, and fellow office bearers. Learned President's Council, learned judges of the High Courts, District Court, Magistrates Court, and all our invitees from the bench and bar from India. Our participants from across Sri Lanka. It is with profound gratitude and utmost respect that I address you at the conclusion of the National Law Conference 2025, held under the theme Building a Resilient Sri Lanka. This conference has stood as a beacon of legal discourse, advance in the cause of justice, the rule of law, and national resilience in the face of evolving challenges. We were grateful for the participation of a distinguished and esteemed panel of jurists and senior advocates from the Republic of India, led by Justice Surikant, the senior-most justice in the Supreme Court of India. The presence of distinguished resource persons, members of the judiciary, senior litigators, academics, and experts from the private sector has imparted invaluable perspectives, fostering a robust and meaningful dialogue on the future of Sri Lanka's legal landscape. A special thank you to all the moderators and coordinators. I wish to take this opportunity to thank our platinum partner, Homelands, bronze sponsors, Tokyo Cement Company, Lanka PLC and LLC, telecommunications partner, Dialog Axiata PLC, media partner, the Maharaja Broadcasting Corporation. Not to forget Markspen Group for their printing partnership. I also should thank associate sponsors Unilever, National Savings Bank, Lanka Hospitals Corporation, DEMO, ABC Shipping, Sanasa, George Stewart's Health, AI Pass, Westgate Interiors, Ceylon Bank, Panisha Banking Corporation, HNB, and SLIT. I must recognize two other partners, Sound Vision, our event partner, as well as the Directorate Management and the staff of Earl's Regency Hotel, who made our conference experience a very memorable outcome. I extend my heartfelt appreciation to each participant for your unwavering dedication, insightful contributions, and exemplary professionalism throughout this gathering. Your active engagement in diverse sessions, ranging from the state of Sri Lanka's economy and its resilience, reforms in commercial law and commercial litigation, constitutional and administrative law, to pivotal discussions on criminal justice, environmental sustainability, artificial intelligence, cybersecurity, digital transformation, labor law, and legal ethics, has enriched our shared pursuit of knowledge and reform. Last but not least, a special thank you to the wonderful team that is the organizing committee of this conference, led by Mr. Priyantha Alagiyavanna, which I'm honored to be a part of. Our team worked hard and applied themselves diligently and met and dealt with many challenges with a smile. So thank you. As we depart these beautiful hills of Kandy, let us carry forward a collective wisdom and commitment to commitments nurtured here, resolute in fortifying our institutions and legal frameworks for the prosperity and justice of our nation. Once again, thank you for your esteemed participation, your spirit, your dedication to the advancement of law and justice. May you all continue to excel in your noble endeavors, and may the spirit of resilience and collaboration illuminated here guide us in the years ahead. I thank you.
Thank you very much, Charana. Ladies and gentlemen, a few short announcements. I've been advised by the organizers to inform all of you how the proceedings will progress after this. All the participants are kindly requested to go back to your rooms as soon as possible because we're strapped for time, and have your bags ready, bring them down, leave them at the lobby, after which you can proceed to have your lunch. The transport will be, for those who are using the transport will be leaving at 3. So at that time, please be available at the lobby to avail yourself of that service. Thank you very much, ladies and gentlemen, for an amazing National Law Conference 2025. Safe journeys. Take care, and God bless.